disciplinary committee is very proactive in terms of the redressal of the grievances or the redressal of the complaints. And I believe when you see the nature of orders which are being passed, that is the first rule book that one should see or that one should consider while undertaking any assignment, be it delay in filing of dissolution application, or be it a transaction by the suspended board during the imposition of moratorium, or be it a timeliness of reporting, be it acceptance of the claim, be it filing of the claim. When a corporate debtor whose CIRP is handling, that corporate debtor itself is a creditor of any other corporate debtor which is under CIRP, meaning thereby the only rule book one should follow, apart from the code of conduct which is there in the IBBI IP regulations 2016, is the order which are day in day out being passed by the disciplinary committee. As far as the discussion in this 3 hours are concerned, that shall confine to, we need to understand the provision of section 217 to 220. Once again, I believe all the participants, being a regular practitioner before the adjudicating authority and appellate adjudicating authority and handling the CIRP or the liquidation process in the capacity of the officer of the court. But I must believe that let us relook at the provision which are very important in terms of that how the IBBI has framed the procedure for initiate this inquiry. It's always like what we have in the Companies Act or any other law. It's call for information, that resulting to inspection, that resulting to investigation, that resulting to show cause notices. That is the one aspect which we are going to take care of. Apart from that, we will be dealing into the regulation as well. We will be taking care of the circulars which are passed by the IBBI to make it clear again and again in terms of various aspects. Be it CIRP cost, I request participant to kindly mute their audio so that at least the matter that the session can be hassle.
You are mute, sir. Nagarji, you are mute.
Okay, so even I have been muted by the host, but I hope I'm audible now.
Okay,
Thank you.
now.
Thank you. So I was on the part wherein my foremost point of concentration was on the disciplinary committee's order, which I shortlisted the recent ones, considering the fact that the all the earlier one must have, many of the participants must have referred to. So we will be dealing into that aspect at the end. But before that, we will be dealing into the aspect of the circular which was intentionally brought in by the IBBI to again or to intimate or to make the IPs a clarity in terms of whenever they give their consent, even as an IRP or RP or as a liquidator, the consent is always accompanied with a declaration that there is no disciplinary proceedings which is pending against them, but there is a clarity which is available in circular but absent in the provisions of the code, that when it will be treated as if the disciplinary proceeding is commenced. There is a circular in that regard. There is also a circular with regards to when you can raise an invoice, what shall be concluded as a part of the CIRP cost, which cost shall not be treated as a CIRP cost. There are certain clarity which is brought in terms of the duties in the interregnum period different. The IRP has not been regularized and the appointment of RP is pending, or when the RP is done with his duty as a resolution professional during CIRP and company has been ordered as a under liquidation, but liquidator appointment is still not taken place. There are certain disciplinary order which will give us an idea that even after the approval of the resolution plan, but if the matter has been assailed before the NCLAT, being a chairperson of the monitoring committee, what all are the duties to take care of, implementation of plan, what are the precautions one has to take as a chairperson of the monitoring committee or as a ex RP. So in this regard, we are going to follow the disciplinary order in detail. We may not be able to take many, but there are few important which we are going to take care of. Apart from that, we will be dealing into the aspect of certain routine nature of the non-compliance has been committed by the IRP, RP or liquidator, which one has to take care of, because even that is also resulting to the matter being referred to the IBBI for initiating the inquiries or inspection or investigation. The important is going to be the IP regulation, wherein we are supposed to take care of certain aspect in terms of the code of conduct as well. That is there in schedule 1 of that regulation, that is IBBI IP regulations 2016. But to begin with is always the code and the provision of section 217 of the code. I'm sharing screen for the sake of convenience. We will confine this discussion to few limited minutes so that we can take care of the circular as well. And post completion of that circular part, we can see some disciplinary committee order which are being passed in the recent past in the month of Feb and March. I'm sharing screen for the sake of convenience of the participants. I hope the screen is visible.
Yes.
Yes.
So this is chapter number 6 of this code, which is dealing into the aspect of inspection and investigation. There is much fight over the subject. A person concerned or person aggrieved, stakeholder. And that's why it's important to first refer that what this code print is talking about. And then we will be dealing into the detailed order which are being passed to explain the terminologies in detail. Section 217 is very clear, and this inspection or investigation is not only confined to me and you as an officer of the court, but it is also confined to all the agencies such as an IPA or even to the IU. But we will restrict our discussion only to the member of the IPA, and that is the insolvency professional who are acting as an IRP, RP, or liquidator. Person aggrieved by the functioning of the IP may file a complaint to the IBBI in such form within such time, such manner as may be specified. And that's why this is always going to be a subject matter of dispute, a person aggrieved, because now the onus will be on the complainant to lodge or to put it before the bankruptcy board that how is aggrieved by the act of the IP. But one thing is very certain, that once CIRP is initiated, it is no longer a personam, it is a matter in rem. And that's why the spectrum is going to be wide. The person concerned or the person aggrieved will somewhere squarely fall within the domain of that aggrieved. Section 217, which is only talking about the complaint, and this is how the action been initiated. Investigation of the IP, but investigation, I believe, is only after calling of certain information, and only upon non-production of the information or insufficient production of the information that results to that inspection or investigation, where the board on receipt of the complaint has a reasonable grounds to believe that the IP, I will only limit my discussion to IP, and that's why I'm ignoring IPA and IU, has contravened any of the provision of the code. And that's why this is very important. Contravention may be a small. I was representing one of the liquidator before the Honorable Tribunal Ahmedabad bench. And the question which was standard upon me was with regards to that, since there was no asset for which the valuation was required, since there was no creditor in the corporate person's balance sheet, there is no claim as such which you have received, then for what reason the delay of liquidation took place beyond 90 days? Because there is a 90 days time frame which is there in regulation 38 of voluntary liquidation regulation. Not only this, the question was also tendered before me as a representative of the liquidator, that why the dissolution application was not submitted, or the dissolution application was not referred on time. Now when you see the voluntary liquidation regulation, there is no time frame prescribed for moving a dissolution application, but these are certain things wherein it is the liquidator who is representing the case of this nature of dissolution application. He need to justify the delay. Has contravened any of the provision of the code, meaning thereby none of the provision of the code, if contravened, will be taken lightly, or rules or regulations or directions made by the board, meaning thereby it's not only confined to your process and you need to comply with the provisions or the regulation, it's also you need to take care of the directions if issued by the board. And my point is not only the directions of the board but also the directions of the adjudicating authority of which you are the officer. It may any time by an order in writing direct any person or persons to act as an investigating authority, and we this investigating authority will be referred as a IA in disciplinary orders. Whenever we are going to refer to the disciplinary orders, the IA will be treated as investigating authority or inspecting authority. So this IA is referred to the investigating authority to conduct inspection or investigation of the IEP. Subsection 3 of this section 218, which talks about the investigating authority in the course of such inspection or investigation, require any other person who is likely to have any relevant document, record information to furnish the same, and such person shall be bound to furnish the document. And it is very relevant that your IPE will also be coming within the scanner. Investigating authority shall provide detailed reason to such person before requiring him to furnish document, but this subsection 4 is very important. During the course of inspection or investigation, they may enter your premises where they have reasons to believe that the documents or record or information of the subject matter of inquiry may found and may seize such document. A detailed report of inspection or investigation shall be submitted to the board by the investigating authority. So this is how the matter gets referred to the board, and it's the board who come up with a show cause notice. 219 is important. Board may, upon completion of an inspection or investigation under section 218, issue a show cause notice to such insolvency professional agency or insolvency professional or IU, and carry out inspection of insolvency professional agency or IU, giving such time to file reply as may be specified by regulation. And that's why we cannot miss out the charm of understanding the time frame which is prescribed in the regulation, because I have seen many a time it is observed by the disciplinary committee while passing an order that the submission or the reply was not submitted or framed within the timeline prescribed. Appointment of disciplinary committee, this is not something so relevant to understand, but it is the IBBI who will constitute DC to consider the reports of investigating authority submitted under subsection 6 of 218. On examination of the report of the investigating authority, that is IA, if DC is satisfied that the sufficient clause exists, it may impose a penalty as specified in subsection 3, suspend, cancel the registration of the insolvency professional. Where any IP, the disciplinary committee may impose a penalty which shall be 3 times of the account of loss caused or likely to have been caused or person concerned on account of contravention, 3 times of the amount of unlawful gain, something which is again a quantifiable, and this is not so relevant for the subject matter of discussion today. Now, this is important that board may take such action as may be required to provide restitution to the person who suffered the loss. That is a compensation to the person who suffered the loss. But loss on account of the contravention from the amount so disgorged. That means this is the extent up to which the order can be passed by the disciplinary committee. If the person who suffered such loss is identifiable and there is a procedure prescribed, There is a procedure prescribed for even a submission of your claim qua loss. And that is what we are going to take care of in the regulation side. So board may take such action as may be required to provide restitution to the person who suffered loss on account of the contravention from the amount so disgorged. And if the person who suffered the loss is identifiable, the loss so suffered is directly attributable to such person. And board may make regulation to specify, and that's why we are supposed to read the regulation. Procedure for claiming restitution. Not so important, but absolutely, if you are on that side of the zone, that side of the beach, wherein you have faced some loss, the period within which such restitution may be claimed, and the manner in which the restitution of the amount may be made, that means a compensation. We are moving to the regulation side, which is again so relevant, and I'm quickly sharing the regulation as well. And these regulations are the IBBI Inspection and Investigation Regulation 17. This regulation called IBBI Inspection and Investigation Regulation 17, associated person, and that means it's not only the you who may face such kind of notice demanding certain information and document, but also if you are a proprietor, it's a you who are going to face the heat. Otherwise, even your partner may face the same. Director, officer, or an employee of service provider, it is confined to in case if you are IPA or IU, a professional or the valuer engaged by service provider. That means the thing may extend to them as well. Professional or the valuer engaged by the service provider or any other person acting on behalf of service provider. Even the disciplinary committee may ask for the information from the associated person as well. You know, disciplinary committee is the committee of whole time member of the board. The whole time member in the disciplinary committee shall not be associated with the investigation and inspection. So they should not be the same. Service provider, it means it's IPA, IPN, IPE as well as IU. Now, this is what is required to be taken care of, how inspection commenced, how investigation conducted, what is the duration by which the DC is going to issue a show cause notice, timeline within which the response to be made. So this is just a formal introduction of regulation 3, which states that it's the board shall conduct the inspection of such number of service provider every year as may be decided by board. Not so relevant, that's why we are not taking care of the same. But the purpose under subregulation 3 includes, apart from other purpose, but this is very relevant, subregulation 4 clause E, to inquire into the complaint received from stakeholder. And that's why the stakeholder or the person aggrieved is always a subject matter of a dispute whenever a litigation initiated before the disciplinary committee, to inquire into the complaints received from stakeholder or any other person on any matter having a bearing on the activities of service provider. And this is one of the purpose. The order under subregulation 3 shall contain scope of inspection. So when the order is being passed for initiate inspection, composition of IA, inspecting authority, timeliness for conducting inspection, reporting of the progress, submission of interim inspection report, and final report, conduct of inspection. The inspecting authority shall serve a notice of inspection to the service provider come se come 10 days before the commencement of inspection. But if they have reasons to believe that service of this prior notice shall cause, or there is always an apprehension that the records of the service provider may be destroyed or mutilated, altered, falsified, or secreted or tempered after the notice is served, it may, for the reason to be recorded in writing, dispense with such a notice. So you may not get that 10 days prior notice as well. The IA may require service provider or associated person to submit record. IA may visit the office of service provider for conducting on-site inspection. Duty of service provider to produce before IA records in his custody control and furnish to IA such statement and information relating to activities. Service provider shall allow IA to have an access to the premises by such service provider or other person on its behalf and extend facility for examination. And you will find this in DC order. Even on this ground, the orders are being passed, not extending the necessary assistance, not provided the examiner or the records which were in the possession of the IB. So even on this count as well, the orders are being passed and the penalties are being imposed. They may examine the statement of any associated person of the service provider in relation to the affairs of the business. They may examine and record the statement as well. It is a duty of the service provider and associated person to give inspecting authority all assistance. Interim report, if the IBBI is demanding such report to understand the development in the inspection procedure, they may also demand for an interim order. So if the board is satisfied from the interim inspection report that there is a gross violation of the provision of the code, the gross violation, rules regulation made thereunder by service provider, and immediate action under subsection 2 of 220 is warranted, and 220 is referring the matter to the disciplinary committee. The board shall refer the matter to DC for appropriate action. And this is a final report. The IA shall send a copy of the inspection report to service provider, requiring comment of the service provider within 15 days. Now see this beauty. It's the inspection report, the draft of which is being forwarded to your IP. IA shall send a copy of draft inspection report to service provider, requiring comment of the service provider within 15 days from the receipt of the draft. IA shall submit a copy of the draft inspection report to the board. The board shall examine the draft report as to whether inspection is complete and satisfactory or require any further inspection, and advise IA accordingly within 15 days of the receipt of the draft inspection report. Meaning thereby it's not only the draft which is being forwarded to the board, but the draft report is also being forwarded to the person against whom the complaint is lodged, and the request is made to file its reply, comments of the service provider within 15 days of the receipt of the report. And this is the beauty, and that further result to investigation. Board may also conduct investigation, which is more a deeper probe of service provided under 218, and 218 deals with both inspection, and that is an investigation as well. Same thing is going to be there whenever any board is referring the matter for investigation, then there is always a scope of investigation to be provided while passing an order. IBBI and investigating authority, so IA also mean investigating authority, shall make every effort to keep investigation confidential and to cause the least burden on disruption to the business of the service provider. Conduct of investigation, IA shall serve a notice of investigation same 10 days prior, and this may also be waived if the notice will cause undue delay in investigation, or there is an apprehension that the records may be destroyed, mutilated, falsified, altered, secreted, or tampered. IA may require service provider or associated person to submit report. This is the same thing. Again, the interim report will be submitted. That is what we are referring. IA shall submit interim report of investigation if required by the board, and if the board is satisfied from the interim investigation report that prima facie there is a gross violation of the code, same thing, then in that case the board shall refer the matter to DC for appropriate action, and on consideration of the interim investigation report, the DC may pass an interim order with appropriate direction to the service provider. Now this is important, what we should reach to, and this is regulation 12. When you see regulation 12, we are also going to refer one 2018 circular, and that has made it clear that from which day it will be treated as if the disciplinary proceedings is commenced. The show cause notice shall be in writing and shall state, this is issued by the disciplinary committee. The show cause notice shall be in writing and shall state the provision of the code which under which it has been issued, the detail of the alleged facts, detail of evidence in support of the alleged facts, provision of the code, rules, regulation, and guidelines thereunder, which is allegedly violated, manner in which the public interest is affected, action or direction that board proposes to take if allegation are established, time within which the noticee may make return submission. Noticee is going to be the service provider. The manner in which service provider is required to respond to show cause notice, consequences of failure of non-response. For purpose of clause E of regulation 1, the board shall take into account, but not limited to following factor. And this is always very important: the gravity of the case, the seriousness of the alleged contravention, including whether it was deliberate, reckless, or negligent, shall take into account, but not limited to this. Consequences and impact of the alleged contravention, including unfair advantage, loss caused or suffered, conduct of the noticee after occurrence of alleged contravention. Show cause notice shall provide 15 days to the noticee to make submission. The show cause notice shall also state if a noticee failed to respond under sub-regulation, it shall be disposed of based on the material on record. Show cause notice shall enclose copy of the relevant document. Show cause notice shall be served on the service provider in electronic form at the mail address provided by the service provider to the board, and the copy shall also be sent through post. Disposal of the show cause notice. There is again a timeline which is fixed in Regulation 13, which you will see. DC, after providing an opportunity of being heard to noticee, shall dispose of show cause notice by a reasoned order. DC shall endeavor to dispose of the notice within a period of 60 days from the due date of receipt of the reply to show cause notice, and that is what is provided. This is 15 days, which you will find in 12 Regulation 3. Show cause notice shall provide 15 days to noticee to make return submission. So after service, on expiry of 15 days, 60 days time frame is provided for the disposal. This is in sub-regulation 2 of 13. DC shall endeavor to dispose the show cause notice within 60 days from the due date of receipt of the reply to the show cause notice, which is 15 days from the date when that show cause notice was served. And what is going to direct? They may pass an order closing the show cause notice without even directions. If no substance is found in the complaint, they may issue warning as well. Suspension or cancellation. This is the most of the orders you will find the warning in less, or the matter in which there is a gravity is less. Otherwise, you will find the order wherein the suspension order or the cancellation of authorization for assignment, AFA, is also being passed. Any of the action under 234 of 220, reference to the board to take action, any other action or direction as may be considered appropriate. Order shall not become effective until 30 days have been elapsed from the date of issue of order, unless disciplinary committee states otherwise. And that's why in majority of the you will find that when order will be effective. Order passed under sub-regulation 1 shall be served upon the service provider and shall be published on the website of the board. And you will find many of the DC order which we are going to refer in detail. These are nothing but a content downloaded from IBBI web portal only. DC shall, in the order passed under sub-regulation 1, require service provider to discharge pending obligation. And this is what you will find in the order itself. Up to what extent he may continue in the pending matters, to continue its function till such time as may be directed, only to enable stakeholder to shift to another service provider and to comply with other direction. And that's why in majority of the matters you are going to see this, that while passing an order, they are going to mention when the order is going to be effective. And this is what you can find in sub-regulation 4 of 13, that order under regulation 1 shall not become effective until 30 days have been elapsed from the date of issue of the order, unless a DC states otherwise. In case where the service provider is an IP, the board shall intimate, very important, the order, all the members, the intimation, board shall intimate the order to all the member of the COC of the CIRP process in which he was acting as an IRP or RP, as the case may be. And we will not be dealing into this restitution aspect, but this is what the general procedure is being adopted. We'll take a pause here, and I would like to have your views in said connection. If somebody has faced and come out with the clean hands, or if somebody has some kind of, you can say, having what we call an experience of representing some other IPs during this process of inspection or investigation, or in handling the show cause notices. I will appreciate your views on the same. If you have some bit of exposure either the things which you have faced in your own case or things wherein you have represented before DC on behalf of your colleague, on behalf of your client who is an IP. I would like to have your views on the same before moving on to the code of conduct, which is there in first schedule of IBBI IP regulation. Well, I appreciate your views, and I will also appreciate your case in which such action was initiated and that was disposed of favorably, if any.
Sir,
If there
we
is,
just received one notice and we send a reply, and thereafter
ma'am,
there was no response at
ma'am,
all.
will appreciate if you can bit introduce yourself.
Am I visible, sir?
You're visible, ma'am.
Yeah, I am Santana Lakshmi, insolvency professional from Chennai. I actually handled a matter wherein the proposed purchaser of the e-auction, he did not actually participate in the e-auction despite my notice, but he wrote a letter to IBBI stating the liquidator has not provided the opportunity for me to purchase the assets of the corporate debtor. I am trying to revive the company, but she is not cooperating like that. He just sent a letter, complaint letter. It's purely allegation. And then I received a letter from IBBI, and I just send a response to that with the relevant documents. I
And the
have
matter was not proceeded thereafter.
thereafter, after the response, it was not proceeded thereafter because they are very much convinced that there is no mistake on my part. It is just a mere allegation. It is a fake, false allegation. It
But
is
my counter to that part is, if you are acting as a liquidator and initiating an auction process, right? Whether you are under any obligation to intimate the one who is interested to be a part of that bidding process. I believe that the person who preferred the complaint must be one unsuccessful resolution
he
applicant.
did not participate in the e-auction at all. That is the fact.
No, no. But
Prior to that,
prior to that, my concern is: was he a part of that resolution applicant or the prospective or the person in the final list?
he was interested. He sent an email to me
Correct.
asking me to discuss on that. He is very much interested to purchase the company as a going on concern.
Correct. But just
Uh,
because of you have received a intent from somebody, you are not under any obligation to communicate that the auction process will start from this day, the bid will close on this day, because that is the
when
information which
we
is there
are
in the public domain.
we are anyway publishing the
Absolutely.
e-auction notice in the
Absolutely.
website and also in the newspaper. It means everyone will get it.
That means there
So,
is no duty casted under the code or regulation wherein you are required to communicate person by person.
yes, yes, yes. I am not duty bound, but still I just intimated to him because he was interested. So I thought, okay, he will
Why I
purchase.
am pointing this out? Why I am pointing this out is very important because I was going through some order wherein it is specifically provided that you should refrain from communicating with in your personal capacity with any of a specific stakeholder. This is something which, again, you as an liquidator is not at all duty bound that you should communicate, because otherwise now that is another allegation on you that for what reason you have informed X and why not Y.
Okay, okay.
Are you getting my point?
He wrote a letter to me and I sent a reply. Kindly participate in the e-auction whenever it is conducted. And
Correct.
the e-auction notice, I have just informed him meeting e-auction is going to take place, but he failed to deposit the earnest money
EMD.
without even paying the EMD, without even participating. He just
Right.
made a complaint against me. Then I just wrote the reply, whatever I sent a reply to him. That also I communicated to IBBA, and thereafter the proceeding was discontinued.
Thank you, ma'am. Thank you very much for sharing your incident
Thank you,
wherein
sir. Sir,
you come out of it.
I have one question also. In
Please,
my
ma'am.
ongoing assignment, in my one of my assignments, I am actually getting some threatening emails from the promoters
The
stating,
authority wherein you can immediately approach after receiving this email is the adjudicating authority. You are the officer of the tribunal. It's a
yes,
tribunal who appointed you, or it is the COC which has regularized your appointment. And my only concern in this particular thing is, if you are getting an email and still you are hiding those email before the adjudicating authority, that may probably come up with another question, that why an e-application was not moved
no,
before the
I
appropriate
have
time.
no idea what to do with those emails. I am just
This is
responding to them.
something
Kindly
you
hold on. The matter is subsidized before the NCLT and NCLAT. Kindly wait until the your application or your appeals are disposed of. That's all. And I
okay,
have just
so
forwarded
they
those mails to IBB also. So what is your suggestion in these kind of mails? If we
so I
receive,
believe that the person from where you are getting an email, they have already approached NCLAT due to some of their grievance, or they must have passed some, or they must have challenged certain order of the adjudicating authority.
yes.
I believe this must be an order pertaining to initiation of CIRP only.
No, no, no. Everything is over in those matters. Actually, what happened? Adjudicating authority has given direction to dissolve the company itself,
Correct.
and I have also given the issued the sales certificate. Everything is over. Only one direction given to another banker involved in that matter. That banker did not release the payment, against whom I just preferred a contempt application. So
Correct.
because of that proceeding, this dissolution application is getting delayed. There is
Understood.
no mistake on my part.
Correct.
But they are thinking that I am purposely delaying the process. So they are just sending emails stating your in order to get some personal gain, you are delaying the process. We will definitely complain to IBBI. So what is there to complain against me? Everything is process duly going on before the court.
Correct.
And since they have not complied with the order, I have just filed a contempt application.
I understood your point, and there is no harm writing the same to IBBA as well. So you being C, you are the service provider. DC is not only mean for the IBBA, is not only mean for taking an action against the stakeholder of the IBBI, but it's also in order to protect the interest of the stakeholder of the IBBI. Correct. So there is no harm writing the same to the IBBI as well
Email
after.
address we can write, sir.
Correct. Mail.
To which email address of the
that,
IBBA
that,
we can
that I
write?
need to refer, that I certainly need to refer, because for every particular reason, they have a separate email ID confined to the same. Say for voluntary liquidation, they have their own wing. For CIRP, they have their own wing. So that I will go and I will
But
certainly
now
avoid.
I have just forwarded to the liquidation email address.
Correct, correct, correct.
Liquidation division.
Correct. So that at least they should be aware of the
I'm just
ongoing issues.
forwarding all the emails to them and asking them to please protect the insolvency professionals. And
Certainly.
please kind see, sometimes the promoters, they are having political influence as well.
Absolutely. I understood your point. Some other participants, if you have faced any such nature of issues in the past, because being IRP or RP or liquidator, you always stays on the gunpoint as far as the promoters are concerned, or as far as the other creditors are concerned whose claims are being partly accepted or rejected. So I will appreciate in case if you have something more to discuss on the said part. Otherwise, we can certainly go to IBBI IP regulations 2016, but the code of conduct is quite important, because whenever you are going to find a DC order, you will find some reference to the code of conduct apart from the reference of yes,
Sir, hello.
yes, ma'am.
Actually, I had one query. In our CIRP case, there was a settlement under 12A. Now, the COC member has given the guarantee up till the month of March, and they told us that they would be providing an additional guarantee if required if the order would not be passed. Now the order of withdrawal was passed in May, and we have received the fee up till the month of March. So can we claim our fees for the month of April and May?
See, if the disposal took place in the month of May 24, I
Yes.
believe you must have incurred the cost up till the date, because up till the date the order is not passed, the withdrawal is not something which will be or which has reached to its conclusion. Correct.
Hmm.
But you
Hmm.
need to substantiate, because this is also a very important point. I've
Hmm.
seen immediately after the admission of the CIRP and when the withdrawal took place, it is always the IRP who approaches the applicant, who approaches for the sake of claiming the necessary reimbursement and fees. But you
Hmm.
should be cautious enough when you are putting your dues, or
Hmm.
when you are claiming your dues, it should be substantiated with all the needful documentary evidence.
Hmm.
Because what I believe is, if the matter is pending before the adjudicating authority for reason,
Hmm.
and if the matter is, for example, listed in the month of May or June 2025,
Hmm.
I as an IRP is not supposed to take, because once the matter is referred to the adjudicating authority under 12A, and
Hmm.
once you have received Form FA,
Yes.
you are not supposed to spend any penny pertaining to the CIRP process. So
Huh.
I believe that that time frame of April or May, there is
Hmm.
no as such any further amount which you incurred.
Huh.
Are you getting my
But
point?
can we ask for a monthly resolution?
Absolutely not. Absolutely not.
Actually, they have put certain conditions that you have to provide the video recording of six matlab, the COC meetings. We have already provided the minutes. So can they put such condition before us that we are supposed to provide the recordings of the minutes of the meeting, and are we liable to provide that recordings?
Acha, so this is the case wherein the COC was constituted
Yes, yes, yes.
and you have received the consent from 90% in value of the creditors.
Yes, yes, yes.
So there is nothing like a recording, since you have already minutized every such
Hmm.
proceedings. This
Hmm.
is more than, there is no provision which mandates you to
Hmm.
record the things and substantiated your functioning as an IRP or RP. No,
Okay, so we cannot file the contempt petition against the COC member for the fees.
absolutely not.
Okay,
Absolutely
okay,
not.
okay. Thank you so much, sir.
Thank you. We should refer to the code of conduct now. I hope screen is visible.
Yes, sir.
Yes, so this is, I believe, the most important thing, or this is one of the rule book. After reading, one can accept, or one can resume, or one can initiate an assignment as an IRP or RP or the liquidator. I will not go into those things which are general in nature. I will not talk about certain things which are always go by our role, or which is something which not does not require any further explanation. But I will certainly identify, and I have shortlisted certain things which, as an IRP, RP, or liquidator, one has to take care of, because knowingly or unknowingly, that impacts our independence, that impact our integrity as an IRP, RP, or liquidator, or on those conduct, on those aspect, we may face some proceedings by or initiated by the disciplinary committee. This is something which I feel is important. In case where the IP is dealing with the asset of the debtor during liquidation or bankruptcy process, he must ensure that he or his relative do not knowingly acquire any such asset, directly or indirectly, unless it is shown that there was no impairment of objectivity, independence, or impartiality in the liquidation or bankruptcy process, and the approval of the board has been obtained. Now, this is very important. Suppose if your relative is bidding in the process, in case where the IP is dealing with the asset, of the debtor during liquidation or bankruptcy process. He must ensure that he or his relative do not knowingly acquire such asset, whether directly or indirectly, unless it is shown that there was no impairment of objectivity, independence, impartiality in the liquidation, and the approval of the board has been obtained. Now, this approval of board part is very relevant, meaning thereby, if you can able to make your point about your no impairment, independence, impartiality, then also you need to go before the IBBI for obtaining their approval. This is another so relevant point. Insolvency professional shall disclose as to whether he was an employee or has been in the panel of any financial creditor of the corporate debtor or the committee of creditor, and to the IPA of which he is a professional member. IP shall disclose as to whether he was an employee or has been a panel in the financial creditor of the corporate debtor, to the committee of creditor to whom this disclosure is required, to the committee of creditor, to the IP of which he is a professional member, and the agency shall publish such a disclosure on its website. So it is upon intimation to the IPA, it is the IPA who shall publish disclosure in its website as well. Very important that IP shall disclose as to whether he was an employee, and there is no look back period provided, or has been in the panel of any financial creditor of the CD. This disclosure is to be made to the COC and to the IP of which he is a professional member, and the agency in turn shall publish such a disclosure on its web portal. This is also relevant. IP shall disclose relationship, if any, with the CD, other professional engaged by financial creditor, also association with the interim finance provider, prospective RA, to the IP of which he is a member within time specified herein under. This is something I'm just brushing upon the things which you are aware of it, but these are those technical part which is generally avoided or which unintentionally get avoided. I'll not deliberate on professional competence because it is again a subject matter of a question, always representation of correct facts. I will not. Timeliness is very important, and that is where I have initiated our discussion with that. Even though because of a smallest variation, and that is what I have specified while discussing on the aspect of one of the matter when I was representing a liquidator, and in that liquidation process in formats he specified no valuation required in absence of any asset, no creditors, no claim received, and still he failed to conclude that voluntary liquidation process within a given timeline as per regulation 38 of 90 days. Furthermore, he failed on that part, but he failed to call a meeting of the contributory, and bearing everything, he failed to submit the dissolution application on time, even after the completion of the winding up. And that's why I have made this point very clear that even though it is the smallest lapse of the timeliness, one may anticipate that something may go against him if complaint is referred. IP must adhere to the timeliness prescribed in the code. Many times we say that timeliness are not mandatory and are directory in nature, but we never know when this mandatory or directory thing go against us. IPA must adhere to the timeline as prescribed in the code and rules, regulation, guidelines thereafter for insolvency, resolution, liquidation, or bankruptcy process, as the case may be, and must carefully plan the action, promptly communicate with all stakeholder involved for timely discharge of its duties. Insolvency professional must not make any private communication, and I was referring to this point while addressing on the aspect of one of the participant. Insolvency professional must not make any private communication with any of the stakeholder unless required by court regulation, rule, guideline, or order of the adjudicating authority. This is very important. Ma'am, you are listening, and you are.
Yes, yes, sir.
Thank you, ma'am.
Sir, I have one more doubt in the previous point. We
Hmm.
have to other to the complaint timelines. But assuming one part of transaction is interconnected without completing that process, and we cannot file any dissolution application or something. So in
Correct.
that case, what can we do? Because liquidation process is completely over. Now,
Correct.
without distribution, can a liquidator file dissolution application?
Not.
Definitely, it is not possible. But in my situation, it is like that. Liquidation is over. Distribution could not be done because the amount has to come from somebody else. They are not releasing the funds. So without distributing the funds, I cannot.
You cannot move a dissolution application till then.
So it is standing there itself for more than half a year, and because of which I am blamed.
No. This is something which is of which you don't have control, because you cannot say that company is wound up unless the amount which you are going to receive is received and distribution take place.
Okay.
Yes.
So this amount, yeah, there is a direction from adjudicating authority as well for this for release of that fund, but they
That's it.
fail to release.
So let the direction be complied by the party from which you are claiming the fund. Unless that fund is received, unless the distribution take place as per 53, that waterfall mechanism, unless you state on your affidavit along with your compliance report that this is the timeline or this is the compliances which has been undertaken, because I've seen the orders being passed by the disciplinary committee even on those aspects wherein the dissolution application is being made without having the copy of compliance report attached. So meaning thereby, this is not a case wherein a matter of concern is there for a liquidator.
Okay, sir. Thank you,
Thank you.
sir.
Thank you. So yes, I was reiterating this point of IP must not make any private communication with any of the stakeholder unless required by the code rules, regulations, guidelines, or order of the adjudicating authority. This is again a point which requires no reference, but again we will find this in order. Non-cooperation. IP must appear cooperate, available for inspection, investigation, carried out by the IBBI, any person authorized by the board or the IPA, whichever in which he is enrolled. Confidentiality is something which is always going with the scope, but occupation, employability, and the restriction. Now, this is something which I believe should require some reference. IP may resign from the assignment subject to recommendation of committee in CIRP, consultation committee in liquidation process, debtor or the creditor in insolvency resolution process of personal guarantee to the corporate debtor as the case may be, and the approval of the adjudicating authority, meaning thereby it is not your formal resignation and things will serve or thing will, you can say the purpose will be served. No, it is very clearly stated, and that is what is provided, that you may resign from the assignment, recommendation of the COC in CIRP, consultation committee in liquidation, debtor or creditor in the personal insolvency matter, and the approval of the adjudicating authority. And that's why this approval of adjudicating authority is something one cannot miss. The IP shall continue to discharge its duties, function, and responsibility till the approval of the resignation by the adjudicating authority, meaning thereby this formal application is required to be made and this formal consent is required to be received. IP must, yes, please.
Sorry to interrupt, sir.
Yes, ma'am, please.
Sir, this resignation part, okay. Voluntarily, if we want to resign, we can resign.
Correct.
But we are going, when continuing the process, there is no problem. But if the COC wants to change the RP or liquidator,
This is not your resignation.
For the reason that they don't want to spend the further money for CARP or liquidation, for conduct of CARP or liquidation. They want a quick remedy. For that purpose, if the insolvency professional is not cooperating, if they want to change, so what would be the remedy for the IP, sir, insolvency professional, sir?
See, as far as I must say that as far as the change in the RP is concerned or replacement of the RP is concerned, it is a prerogative on the part of the COC. It's a
So
pre. Hmm?
IRP is over, and they proposed me for the liquidation.
Hmm.
But the intention is to file early dissolution.
No, 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 no. See,
I have no problem to file early dissolution because there is no asset at all with the
correct.
corporate debtor. But unfortunately, I received a complaint against the promoters, and they insisted, even other stakeholders insisted for forensic audit. So when we had an agenda regarding forensic auditor appointment and all that, so the COC, that time SEC was not constituted.
Hmm.
Within 60 days from the commencement of LCD, we can constitute SEC. Prior to constitution of SEC itself, when they are COC, they want to change the liquidator for the reason that early dissolution was not filed. And this is prolonging. Thereby, they may happen to incur a lot of money towards the liquidation cost. So they
Hmm.
are not interested, because anyway, there is no asset. They are not going to recover anything. So the point is, why unnecessarily to spend money where there no possibility for recovery. So
There is an insistence on the part of this committee, this stakeholder committee, that you go for an early dissolution rather than opting for the entire procedure of liquidation. This is your sum and substance of the issue.
they are asked, yes, yes.
Correct. So
So
in
we
hmm,
cannot comply with all their desires, wishes.
absolutely, absolutely. Meaning thereby
Because we
in
are
that.
duty bound when the complaint comes, even in the liquidation order itself, it says we have to liquidator is directed to investigate on the puff transaction, if any.
Hmm,
So without investigation, if I am going for early dissolution, in future I will be questioned. So I want to investigate on it. And further, there is a question, there is a request from the promoter side also. One of the promoters given a complaint. So I cannot completely ignore the complaints. I cannot completely ignore all the investigation and go for early dissolution. So in
right,
this scenario, they want to change the liquidator.
correct.
So what is the remedy? Is there any remedy for me? Or
See,
I
if
can just,
I
since
am
they
coming,
decided.
I'm coming to your concern.
Hmm.
See, they will change the liquidator by either nominating their person as a liquidator or by preferring an application before the adjudicating authority. While moving an application, that interlocutory application for replacement, they will specify the reason as well. You are going to represent your case, that why the early dissolution application is not something you should opt for, reasoning to this pendencies or developments. I must say that this ground of replacement is not going to be accepted by the adjudicating authority. Right. And one more thing I would like to
Can I
confirm.
object or leave it, sir? Because I
So
will not party in that
what is the
application.
outcome in your case then? May I know
Pardon?
the outcome of your case?
No, it is not that decided. So I
No, no.
don't.
But so the adjudicating authority has not dealt upon your application or the application of
It
COC.
is the application is yet to be preferred by the
Okay. Okay.
COC.
Now, one more thing. My point is, whether you opt for this PUFE application based on the recommendation of COC or SCC, or it is your independent call, is my concern. I have replied to that. My question is, when you move 4366 application, this is based on your own judgment, or whether it is based on the COC's request or based on the COC's insistence, is my question.
Should be own judgment by the liquidator.
Okay. So, meaning thereby the COC's insistence in this connection can be ignored. We will be dealing into an order of this nature.
Okay, sir. Thank you.
Thank you. So, I'm moving ahead with my code of conduct. The IP must not engage in any employment when he hold AFA or when he is undertaking an assignment. Very important. With regards to remuneration and cost, we are going to dealt with a circular as well. IP shall, while undertaking assignment or conducting process, that is CIRP or liquidation, exercise reasonable care, diligence, and take all necessary steps to ensure that CP, this is very important, that's why I've highlighted, complies with the applicable laws. You should not ignore this compliance part at all, because it is your responsibility during the process of the CIRP that whatever are the compliances which are overdue. I've seen in many of the cases the financials are not being signed, the financials are not being filed, the meetings are not being called out, the auditor is not responding, or auditor is not signing the audit report or issuing the audit report, because the financial statements are not being signed by the SBOD, suspended board of directors, or financials are not being signed by, because the suspended board of directors are putting this frame that once CIRP commence, we have been suspended, our role is no more, and the RP is of that opinion that your power is suspended, not your duties. But as far as the compliances are concerned, this compliance shall form a part of the duty of the IP only. And that's why this is quite relevant. That IP, while undertaking assignment or conducting process, exercise reasonable care, diligence, and all other necessary steps to ensure that the CP, corporate person, complies with all applicable laws. IP shall not include, or IP, insolvency professional shall not include any amount towards any loss, including penalty, if any. And this is a very relevant point, that it shall not form a part of the CIRP cost. If any penalty is imposed by, say, for example, the ROC has imposed a penalty, adjudicating officer 454 of the Companies Act 2013, in the capacity of the adjudicating officer, if ROC has imposed a penalty on the corporate debtor which is under CIRP, make sure IP shall not include any amount towards a loss, penalty, if any, in CIRP cost or liquidation cost incurred on account of the non-compliance of any provision of law applicable on the corporate person while conducting CIRP, fast track or resolution process or liquidation process or voluntary liquidation process, that shall not form part of the CIRP cost. I've stopped sharing that part, and we will be dealing into certain circulars which are relevant in nature before addressing upon the final concern pertaining to the orders being passed by the disciplinary committee. If you have anything to share, I'll be happy to have you for a discussion's sake. If not, we will be dealing into the aspect of circular. Yes, participants, please share your views on that aspect, share your experience as well, share your incident, or share your order wherein you have represented some of your fellow IP before the disciplinary committee, an order whether goes in your favor or against, but what's the crux of the case. Meantime, I'm sharing the relevant IBBI circular on screen. Now, this is Extremely sorry, there was a power cut at my place, so I was temporarily disconnected. I'm sharing the screen pertaining to that circular, which talks about the commencement of disciplinary proceedings. You see this circular, very old circular, but this circular has made the things very clear that when it shall be treated as if the proceedings are initiated. Because during the entire phase, when you give your consent as an IRP or RP or as a liquidator, or even as a representative of the home buyers, authorized representative, this declaration is required to be given. But as I said, that in the code you are not will not find anywhere with regards to when there shall be, or when there it will be considered as if the disciplinary proceeding is commenced against you. And that's why this is bit relevant, or the circular, though it is very old one, but it's going to help us out in terms of understanding that when it shall be treated as if the disciplinary proceedings are commenced. Now this is 23rd April 2018. The IBBI NV suggests that the IP may be appointed as an IRP, RP, or liquidator or bankruptcy trustee if no disciplinary proceeding is pending against him. And some of this provision are extracted as well. We'll see to it. If you can see this 7 subsection 5, wherein it is mandatory that you need to propose an IRP in section 7 application, there is a wordings which clearly states that no disciplinary proceeding is pending against the proposed RP. 9 subsection 5, the similar language, there is no disciplinary proceeding against the RP proposed, if any. 16.2, where application for CIRP is made by a financial creditor or the corporate debtor, as the case may be, RP as proposed respectively in the application shall be appointed as an IRP if no disciplinary proceeding is pending. 16.3, proposal for IRP under 9 shall be appointed as an IRP if no disciplinary proceeding is pending against him. 16.4, board shall within 10 days of the receipt of the reference. Now this is no longer required because every NCLT do have their own panel. But the point is disciplinary proceedings pending. And this clarity you will find in this IBBI circular dated April 2018, 23rd April 2018. The code, however, does not define disciplinary proceeding. Section 219, which deals with that show cause notice. Section 219 envisages issue of show cause notice following an inspection or investigation. And Section 220 envisages a constitution of disciplinary committee for consideration of inspection or investigation report. Various regulations made under the code envisage issue of show cause notice based on the finding of the inspection or investigation or on material available on record. They also envisage the constitution of disciplinary committee for disposal of the show cause notice. A show cause notice is issued after the application of mine to the material available on record or on consideration of the inspection or investigation report. DC dispose of show cause notice by a reason order in adherence to the principle of natural justice. Reason order carries the determination of contravention. Rules, regulation, guidelines, directions, order. Disciplinary proceedings commence with issue of show cause notice. Conclude with disposal of show cause notice by a reason order. Now, you will find this para very useful. It is therefore clarified that a disciplinary proceeding is considered as pending against an IP from the time he has issued a show cause notice by IBBI till its disposal by DC. Very important. It shall be considered as pending against an IP from the time he has been issued a show cause notice by IBBI till disposal by DC. And IP who has been issued a show cause shall not accept any assignment, fresh assignment as an IRP, RP, or liquidator under the code. This is relevant one dated 23rd April 2018. Having few more to share. And this is what I was referring to while discussing the code of conduct of schedule 1 of the IBBI IP regulation 16. And this is what you will find in Gen 2018. It was made clear. IP to ensure compliance with the provision of the applicable laws. A corporate person undergoing CIRP fast track insolvency liquidation process, voluntary liquidation process under IBC need to comply with the provision of the applicable laws during such process. Example is provided that the CIRP of a listed company which is listed on exchange need to comply with every provision of the SEBI LODR unless a provision is specially exempted by the competent authority or become inapplicable by the operation of law for the corporate person. Meaning thereby, this is going to be a responsibility in your part. It is hereby directed that while acting as an IRP, RP or a liquidator of this corporate person, IP shall exercise reasonable care, due diligence, take necessary steps to ensure the corporate person undergoing the process under the code comply with the applicable laws. It is clarified that if the corporate person during the aforesaid process under the code suffer any loss, and this is what we have recently studied, including penalty if any, on account of non-compliance of any provision of the law, such a loss shall not form a part of the CIRP cost or liquidation cost. And it is clarified that the IP will be responsible for the non-compliance of the provision of the applicable law if it is on account of his conduct. Very important. One more to share. And this is qua fees. This is of January 2018, that is 16th January 18, which is all together with regards to fees payable to an IP and other professional appointed by the IP during the process. 206 provides that only a person registered as an IP with IBBI can render services in IP under the code. 23 deals with Section 527 of the code, that is 23 read with 527 of the code, that is Section 5 Clause 27, require that IP who is appointed as an IRP or RP shall conduct the CIRP including fast track process. The fee payable to any person acting as an RP is included in the CIRP cost which need to be paid in priority. This is something which you are aware. Now, the point of concern is in view of the above is clarified that the insolvency professional render services for a fees, which is reasonable reflection of his work, raise bill, invoices in his name towards such fees. And such fees shall be paid to his bank account. Any payment of fees for the services of an IP to other person other than IP shall not form a part of the CIRP cost. This is again very relevant when the invoices are being issued in the name of their associates. And this is again which one has to take care of while appointing the valuer during the course of CIRP. Valuation under the IBC appointment of registered valuer only, and this is the IBBI registered valuer. It is reiterated that appointment of any person other than registered valuer is a valuer registered with the IBBI on or after 1st Feb 19 to conduct any valuation required under the IBC or regulation made thereunder, including IBBI insolvency resolution for corporate person or liquidation process regulation, is illegal and amount to violation of the circular, and payment whether fees or otherwise to any person other than registered valuer, that is IBBI registered valuer, for valuation referred in paragraph 1 shall not form a part of the CIRP cost. And last but not least of June 18. And this is indicating again on a cost part during CIRP or liquidation. Keeping in view of the above, the IP is directed to ensure that the fee payable to him, fee payable to IPE, fee payable to RV, other professional, other expenses incurred by him during the CIRP is reasonable. Fee or other expenses incurred by him are directly relating to and necessary for CIRP. Fee or other expenses are determined by him on arm's length basis, consonance with requirement of integrity, written contemporaneous record for incurring, agreeing to incur any fees or expenses. Supporting record of the fees and other expenses incurred are maintained at least for 3 years. Approval of the COC for the fees or other expenses is obtained whenever approval is required. CIRP related fees and other expenses are paid through banking channel. No fees or expenses other than what is permitted under the code with regulation is included in CIRPC. No fee or expenses other than IRPC incurred by IP is borne by the corporate debtor. Only insolvency resolution process cost to the extent not paid during CIRP from the internal resources of the corporate debtor shall be met in a manner provided in section 30. So meaning thereby, there is a clarity on that aspect that what shall be covered, what shall not be covered. And that's why when you will see this IPBI insolvency professional regulation, and we have studied that IP must ensure that he maintained written correspondence for every reason taken, reason for taking such reason, and information and evidence in support of such reason. This shall be maintained so as to sufficiently enable a reasonable person to take a view on the appropriateness of the reason and the action. IP must provide services for remuneration which is charged in a transparent manner, reasonable reflection of the work necessarily and properly undertaken, and is not inconsistent with the applicable regulation. IP shall disclose the fee payable to him, fee payable to IPE, fee payable to professional engaged by him, and fee payable to professional agency of which he is a professional member, and the agency shall publish such a disclosure on its website. IP shall not accept any fees or charges other than those which are disclosed and approved by a person fixing his remuneration. In view of the above, it is clarified that the insolvency professional shall render services for a fee which is reasonable reflection of his work, and you will find this extract in many order. Raise bills, invoices in his name towards such fees. Such fees shall be paid to his bank account. Payment of fees for the services of an IP to other person other than IP shall not form a part of the insolvency resolution process cost. Similarly, any other professional appointed by IP shall raise invoice in his name towards such fees, and fees shall be paid to his or in its account only. We will not be dealing into the aspect of what shall be treated as reasonable or what shall be treated as unreasonable. But yes, let us eye upon, or let's have a look on. And this is just in a summary manner. Otherwise, we will certainly going into the aspect of the DC order. We will be looking after the order of the disciplinary committee. But before that, let's have a look on this file, which is itself an extract of the IBBI only, in terms of which are the routine nature of the contravention being committed by the IRPs or the RPs or liquidator. Few of them are inclusion of ineligible cost of COC in IRPC, and this is what I was referring to, that 12th June 18 circular, which is having some, and this is what I mentioned as well, that you will find this in several DC order. Inclusion of ineligible cost of COC in RPC. What is included and what is not included. That's why the circular has made it very clear. And this is what you will find in many of the DC order, that this is one of the subject matter of complaint. So this is based out of the analysis of the order passed by DC. Contravention by IP, qua, IRP, RP or liquidator as found in this matter are summarized. So I will not go into the detail of this aspect. Payment to the creditor during moratorium, and this is something which is very sincere in nature. Because 14(1)(b) clearly prohibit an action by CD, including transferring or encumbering or alienating or disposing of the asset of the CD. However, it has been noted during few instances that IP have made prematurely payment to creditor during CIRP. towards amount outstanding as on insolvency commencement date, which is in contravention of 14(1)(b). Such action not only impact the interest of remaining shareholder, but also may be seen as compromising the independence and integrity of IP. This is very relevant, and I'm just pointing out few, which are the summary of several DC orders which are being passed. Non-filing or delay in filing of application for cooperation. We have seen in several DC order wherein the submission which is made by the concerned insolvency professional against whom the complaint is made, that he has not get the necessary cooperation from the suspended board of directors. And it's always important that if it is the case, then you should not delay, that you should not take further time to raise the issue before the concerned adjudicating authority. CIRP require cooperation of the promoter, suspended director, management. 19 of the code enable IRP RP to move an application before the adjudicating authority for seeking directions in case of non-cooperation from the personnel of the CD, its promoter or other person for suitable direction. However, there were the instances where the IRP RP, despite having non-cooperation from SPOD or personnel of the CD, has failed to file application under 19 or filed it at so late that it lost its purpose and effectiveness. Very important. And this is something which, and as I mentioned in the very preamble itself, that this is going to be, or the DC orders are basically, that should be your first rule book. Because what is being happening in majority of the CIRP or liquidation, that may encounter with you as well. So what is the stand taken by the adjudicating authority, or what is the stand taken by the disciplinary committee is very important. One can make out of this DC order. Non-representation of CD in judicial proceeding, very relevant. You will find this in 25(2)(b) of the code, that cast and duty on RP to represent CD in judicial, quasi-judicial and arbitration proceedings. However, it has been observed that there was a non-representation of the IP on behalf of CD in such proceeding that has resulting to non-realization of the benefits accruing to the CD and adversely impacted the value maximization concept of CD. Very relevant. Appointment of professional on basis of recommendation of COC, and that should not be the case. So duty of the RP to preserve and protect the asset of the CD, including continuing the business operation. As far as 25(2)(d) is concerned, RP IRP may appoint accountant, legal, other professional for its purpose. As the fee of this professional ratified or fixed by the COC forms a part of the cost, RP should exercise due care while appointing such professionals so as to keep CIRP cost reasonable. However, it has been observed that the IRP RP are appointing professional on recommendation of COC without exercising their own independent diligence. This compromises the independence of the IP and impose avoidable cost on the CD and other stakeholders. Very relevant. Non-forming an opinion pertaining to avoidance transaction, and that is something whereas a timeliness is fixed by the regulation 35A and 40A. As per 25(2) clause J, read with regulation 35A and 40A of the CIRP, it is a duty of the RP to file an application in respect of avoidance transaction, be it preferential, undervalued, or extortionate, or fraudulent. It is important to resort to this provision with a view to claw back the gain made by the erstwhile related party or the promoter of the CD. RP need to form an opinion on such transaction within 75 days, file an application within, now it is 130 days. However, it has been observed that RP failed to form their independent opinion and abdicated their duty in favor of COC to perform an opinion. This clearly reflects serious dereliction of duty and breach of the trust, addition to depriving the stakeholder of their legitimate dues. Very relevant, that was as well. Related party transaction without prior approval of the COC, and this is again very important, wherein majority of the COC, majority of the DC order, you will find the aggrieved has referred the matter before the IBBI, and the order in this connections are being passed. So 5 clause 24 and section 524A of the code explicitly defines the term related party in relation to CD as well as in relation to an individual. Section 28(1)(f) of the code requires RP to take approval of COC before undertaking any related party transaction during CIRP. However, it has been observed that the IRP or RPs undertook such transaction without consent or the approval of the COC in violation of 28(1)(f). Delegation of authority without prior approval of the COC. And this is, I said, that if I'm the IP, I'll raise the invoices for the services which are being rendered, and I cannot delegate my power as an IRP, or I cannot delegate my duties or my role and let the other person to raise an invoice for that. No. 28(1)(h) of the code, that is section 28 subsection 1 clause H, which define the instances where the approval of the COC is required. IP must take prior approval of the COC before delegating his authority to any person for performing various duties under the code. However, it has been observed that the IRP and RP are delegating their authority for taking various action without seeking the prior approval of the COC, which is in violation of section 28 subsection 1 clause H of the code. And this require no explanation, non-adherence to the timeliness for circulation of minutes, non-taking approval of the fees, not taking approval for fees of professional. This is again regulation 34, which mandates that it's a COC who shall fix the expenses to be incurred on and by the IRP or RP, which include fees to be paid to professional, and expenses shall form a part of the insolvency resolution process cost. On several occasions, the IRP RP failed to take the approval of fees of professional from COC as provided in the regulation. Providing information without confidential undertaking so relevant. 29(2) of the code require RP to provide access to all relevant information of CD to RP to RA, subject to the resolution applicant or the prospective resolution applicant undertaking to comply with the confidentiality requirement. Regulation 36(4) provide for taking an undertaking of confidentiality from every prospective RA and COC member before sharing information. Regulation 35(2) of the CIRP require RP to obtain undertaking of confidentiality from every member of COC before sharing with them the report of registered valuer containing detail of the fair and liquidation value. After receipt of the resolution plan, despite having an explicit provision, it is being noted that the RP shared information, memorandum, and report of valuation with member of the COC or with prospective RA in violation of 29(2) and Regulation 35(2) and Regulation 36(4) of CIRP regulation. Non-cooperation with, this is what I have referred before, that when action is initiated in 217 or 218, it is an obligation not only on your part, but also a part of your associate or your person who is handling or who is assigned or who is associated with you, if you being an IP or an IPE or an IU or even as an IPA, that you should cooperate with the IA, that is inspecting authority or investigating authority. Regulation 4 of the IBBI inspection investigation regulation read with clause 18 of the code of conduct. Duty is on the IP to provide assistance to IA, inspecting authority. In connection with the inspection, the IP is required to produce all record in his custody control and furnish the statement and information which the IA may require. IA is the inspecting authority or the investigating authority. Non-disclosure of the fees and relationship. This is one of the major concerns. Regulation 34A of the CIRP as well as circular dated 16th Jan, which we have seen. The board require IRP or RP, as the case may be, to submit relationship and cost a disclosure in a manner required by the board, as it is duty of IP to disclose the fee payable to him as well as the fee payable to the professional engaged by him while performing the duty as an IP. It is also his duty to disclose relationship he has with the IP or with the professional engaged by him. During the course of various inspection, it has been observed that IP failed to file the said disclosure or filed the same with substantial delay, which is a breach of Regulation 34A. Raising invoices for service rendered by IP in the name of his or her firm. That shall again not be allowed. In the name of his or her firm. IP is an independent professional who is registered with the board, and his capacity therefore should charge the requisite fees for his or her assignment as an IRP, RP, or liquidator in his or her own name, and the fee should also be credited to his or her account, not in the firm or not in his a company's account. Appointment of non-registered valuer, and that is what we have seen, as well as in line with the IBBA circular dated 17th October 18. Acceptance of assignment without AFA is something which one should take care of. Not taking control and custody of the asset of the CD, this is relevant. This is relevant. As per 18(1)(f), one of the duty of an IRP is to take the control and custody of the asset over which CD has an ownership, as recorded in the balance sheet of the CD or with IU or with depository of the security or with other registry that record the ownership of the asset. 25(2)(a) of the code provide that duty of RP, which makes it mandatory for RP to take immediate custody. And there is nothing like a physical custody or a symbolic custody, unlike we have in Sarfasi. Including the business record of the CD. Despite the above provision, it has been observed that IEP failed to take control and custody of the asset of CD. That is in contravention of 18 and 25 of the code. Inclusion of interest incurred after ICD in claim, and that should not.
One small question, sir.
Please, ma'am, please.
Sir, like when the IRP or RP is appointed, the visiting the corporate debtor's premises and affixing the notice itself is a proof that we have taken control of the asset, or anything else more is required, sir? Because in one of my assignment, bank is the COC, sole financial creditor as the COC. They have already taken the possession of the assets of the corporate debtor under Sarfasi, and they have affixed their notice, everything on the gate, on the entrance of the asset. Okay, now should I pay the security fees or anything, or let them continue to pay that? Taking possession of the corporate debtor means what?
My question to you in this connection is, you said you have only one COC member, and that is a bank who already initiated the necessary action under the Sarfasi, including taking physical possession, as you have mentioned. That action after initiation of CIRP is tenable or not?
Pardon, sir?
My question to you is,
they've already taken possession.
My question is, that action must have been initiated prior to initiation of CIRP.
Yes.
So once CIRP is initiated and application is admitted under 10, 9 or 7, can that action be continued by the bank in Sarfasi against the property of the CD is my question to you.
As per, in view of section 14, it should be stayed.
And that is what my point is.
So it means that you're trying to say, like, I have not taken control of the assets.
You have to take control. You cannot rely on the action initiated by the banker under Sarfasi that they have already sealed the premises, and that's why you are free from your responsibilities of taking the possession of the premises. As far as
we need to change the security.
Absolutely, because when you see the CIRP procedure, you need to make all the attempts to keep a corporate debtor as a going concern. I'm talking from that perspective as well.
Oh, it's a closed premises.
No. I'm addressing on that aspect as well. Now, suppose if that was functioning, not to its full extent, but it was functioning, then what step you should have taken? Whether the Sarfasi action would prevail in that case? It's meaning thereby it's you who need to take the necessary custody, and custody includes not only giving an intimation to the public that this company is in CIRP and one should not deal with the asset of this corporate debtor during the court. This is not on, this does not indicate taking of the custody. Custody means the custody, that you should make sure that this property or this premises of the CD is not being misutilized. Many a times we have seen the corporate debtor is still in possession of the promoter, or the company's directors are still in possession of the physical possession of that property, or rather calling it possession. They generally sit in that premises, or they do not, you can say, it's not required that you should make the premises empty, but make sure it should be within your control. It should be within the control of that particular premises. The lock and keys should be available with you. It is you who can take, because once the company will goes into the liquidation, it's you need to go for an auction sale. Many of the auction purchaser, they would like to visit the premises. They would be willing to go through the premises, the vicinity of the premises, the documents pertaining to the premises. So when an action is already initiated by the bank under SARFAESI, whether you will be having any control or custody over the same is my question. I hope I answered your point.
Yeah, thank you so much, sir. But the complication here is the property belongs to the individual director. He has given the portion of property alone for the corporate debtor on lease. So I cannot take control of the entire property because it doesn't belong to the corporate debtor.
I agree to this. I agree to this. But now again, 14 is also dealing into the aspect of the lease as well. Now, suppose if the property is of an individual promoter given on a lease to the company, whether the lessor can take an action for you can say on the basis of that lease deed, for cancellation of that lease deed, or to take the custody back, is my question once again.
Since
No.
moratorium is on, they cannot do anything now.
Hmm.
Until the CARP is closed, they cannot take any action.
That's why. Meaning thereby, you cannot solely rely upon the action which is taken by the bank in SARFAESI and cover up your duty that it is already within the control and it is within the well custody of. Because something, in case, if something wrong happen with regards to machinery or any valuables inside the premises, now the question will come, who will be held responsible for that loss, is also a point to address.
Correct, sir. Thank you, sir.
That's fine.
Am
Thank
I
you.
audible, please?
You're audible, sir.
Right, I'm Sanjay Khandelwal, I'm an IP. I have just a point, a question regarding, pre-CIRP costs.
Yes, sir.
Let us take the example of a going concern which is admitted into CIRP in the middle of a month. Now, essentially, you see salaries of employees working there accrue at the end of the month. So my question is, if it is admitted in the middle of the month, should I, at the end of the month, should I pay the salaries pertaining to the portion of the month which accrued prior to initiation of CRP commencement date? That is my question. What is your opinion on that?
Yes, sir. So if I understood your question well, so your point is CIRP was commenced, or the application of 7, 9 or 10 was admitted in middle of the month.
That's right.
Point number 2, that CD was also a going concern only. So it was a running entity.
Yes.
Your point is the liquidation the CIRP commencement date, or the date of initiation of the CIRP, is the cutoff date up to which we generally accept the claim.
That's right.
Now, your concern is whether the claim of those employee be accepted up till the date of the claim which was subsisting as on insolvency commencement date, or for the entire month.
Yeah, with a specific point that you see their salaries were duly paid till the end of the previous month.
I understood your point.
Only 15
your point
days
is only
due.
pertaining to whether to consider their claim for the time they have undertaken their you can say their performance up till the date of liquidation commencement date, or for the entire month. Now the point is, you being an IRP during that phase, or you being an RP during that phase, your only concern with regards to this process is to keep the company as a going concern, but we know this is a theoretical aspect of the code. Otherwise, practically, when company goes into CIRP, everything becomes a standstill.
No, point is, see, I'll
So
tell you
I'm
what.
coming to your point. I'm
Yeah,
coming
yeah.
to your point. My point is whether, now question to you is whether those employee for which you're concerned about, whether they have committed or whether they have performed any role after commencement of CIRP
That's the
is
point I'm
questionable.
trying to make. You see, the companies are going concern, the factories are running.
Hmm.
Okay, the CIRP is initiated and it is accepted.
Hmm.
Now you see, till let us say it was accepted, CIRP was initiated on the 15th of March.
Hmm.
Till 28th of February, their salaries have been paid.
Correct, sir.
On 31st of the March, since they're working in a going concern, their salaries again accrue. Now the practical problem
So
is,
there will be a bifurcation, sir. Up till
yes,
the date of CIRP commencement,
so
their claim will be accepted. After that, that amount shall form a part of the CIRP cost.
this is the point I'm trying to make. You see, this is a going concern, and the practical problem that arises is, bifurcating it for 15 days. 15
Understand?
days, and you see, that is something that leads to a lot of issues with employees.
Correct.
They say that it's a going concern, there's a going concern expense. Why should you bifurcate it? So, what is your viewpoint on this
And this
in
is my
terms of
viewpoint is, sir,
disciplinary proceedings?
my viewpoint would be their claim will only be accepted up till the CIRP commencement date. Even though they have extended their role as an employee of the company beyond CIRP, this being a company as a going concern, or that was a running entity. Because every expenses pertaining to a period after the commencement of the CIRP,
That will be CIRP cost.
that will be CIRP cost.
That's right.
Absolutely. So
But
my
for those
viewpoint in this,
15 days, you believe that we should accept a claim rather than give them the money.
absolutely, sir.
Okay, because you see, this is something that causes a lot of problem in going concerns. You see, employees don't want to, submit claims for 15 days. They say that we've been working continuously. What is the point of seeking claims for 15 days when
Absolutely,
you
sir.
paid the salary?
And
So
if
this
you
is a
are not,
practical issue we face.
I understood. Because if you are not going to admit, ultimately that is going to impact your role, and you will not be in a position to keep that operating unit operative. So this happens.
That's the point. That's the
Absolutely.
point I'm trying to make. So that's one thing. The second thing is that you pointed out, of course, it was mentioned here about raising bills and invoices in individual names. There's a very recent circular that permits raising invoices by IPs and by professionals in the names of their firms. So I think that stands modified to that extent.
Uh, in what circumstances, that is what we are going to dealing with a DC order. When
Right.
you can and when you cannot.
Okay.
Yes.
Fine.
And
Thank you
one
very
more
much.
point which I would like to address on.
Yeah.
Now, say for example, if you are admitting the claim of that employee or of that worker for a period which is after the date of CIRP commencement date.
No, that question does not arise.
No. Suppose
See,
if you pay. Now, my point is, suppose if you pay, there will be a question from the other stakeholder with regards to a preferential treatment again.
no, 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 no. No, I do not agree to that because I'll tell you what. See, once the CIRP has been initiated,
Hmm.
after the commencement of CIRP, all the costs incurred in keeping the concern as a going concern,
That shall form a part of CIRP
that
cost.
shall form a part of CIRP cost. So even if I pay, I'll need to take the approval of the COC.
COC.
Subject to COC approval, of course. But once the COC approves it is CIRP cost, there's no problem. It is
Absolutely.
only that you see 15 days money I'm not paying to them in an intervening period, which leads to practical problems. That
Absolutely.
practical
Practical.
problem is what I am concerned
I
about.
agree with you, sir.
Right.
Thank you, sir. So, keeping that part, I'm just sharing the screen as well. So, few more points which on the basically these are the grounds, or basically these are the instances and which is just a brief of what we have found in the disciplinary committee's order 18th. Inclusion of interest incurred after the ICD in claim. Now, this is a very relevant point. A relative point we were discussing just before this discussion. So, regulation require the IRP RP to verify each claim of the creditors on liquidation commencement or the insolvency commencement date. Further, various forms provided in the schedule of the CIRP regulation for filing of claim also provide that the claim of the creditor should be the total amount of the claim, including interest, as on ICD. However, in some cases, RP has included interest amount charged or incurred after ICD in the claim amount of FC, resulting in addition voting share, and that impact the value or that impact one's locus in the COC. The you can say voting share as well. Deferment of the publication of the invitation for expression of interest. The code envisages a resolution of CD in a time bound manner for maximization of its value of the asset. Invitation for EOI is a very important step to achieve the time bound resolution process. Should not be deferred. RP had in some instances deferred the publication of EOI on request of suspended management or other stakeholder on the grounds that the parallel settlement negotiation is going on. This reflects that RP in such cases was not independent and acting under the influence of the other stakeholder, non-adherence of the timeliness, and non-preservation of the records, acceptance of UI after the time specified in invitation. So these are certain subjective issues which are being dealt by the IBBI through its disciplinary committee, and we will be taking care of certain orders which are of the very recent past before we conclude today's session. But I would like to take a break of 10 minutes so that we can again incept the discussion straight at so at 4:05. We will be starting the discussion again at 4 o'clock with 5 minutes. So, and we'll be dealing into the aspect of the DC order, certain orders which are a part of a very recent adjudication. So, we'll be resuming in 5 minutes or in maximum by 7 to 10 minutes. Thank you.
Okay, sir. Thank you.
पढ़ को
If the participants are connected after this break, with their consent, I would like to initiate with a very recent order of disciplinary committee. If you have joined, please acknowledge so that we can initiate the discussion to the last aspect of today's session and few of the disciplinary committee's order.
Yes, continue, sir.
Thank you, sir. Hope the screen is visible.
Yes.
So this is 4th March 2025 order, just 20 days back. We go into the background of the case. Certainly, it will take some time because we are going to oversee what is committed by the RP, what is not committed by the RP, and what were the submission and what is the ultimate call or the reason which is taken by the disciplinary committee in this case. So, background of the case is it is a Chennai bench which has admitted the application filed under 9 of the IBC initiating CIRP of Uniply Industries Limited. Was initiated wide order dated 10th, that is 4th of October 2021, and appointed Mr. Sundar as an IRP, who later on confirmed as an RP, subsequently adjudicating authority by its order of May 23 ordered liquidation of the corporate debtor, appointed Sundar as a liquidator. Board, in exercise of its power under 218 of the code, read with regulation, has initiated investigation, the conduct of the Sundar. In the CIRP or liquidation of the CD, the IA served, and this is the investigating authority, served the notice upon Sundar on November 23. Sundar submitted its reply. So this is the background. He alleged the contravention or submissions of the IP and the findings. See, this is very important. It's a non-filing of the claim on behalf of Uniply Industries Limited to Uniply Decor Limited. So Uniply Decor is one of the company which was also in CIRP and which was using the trademark of Uniply Industries Limited. Very interesting one. It was observed that the brand Uniply was owned by CD and this brand was licensed to Uniply Decor via trademark license agreement of 17. The use of licensed trademark for a period of 10 years from the total consideration of 75 crore payable on a quarterly basis. However, no payment were received by the CD against the same, and hence the agreement was terminated by Mr. Sundar on 10th March 23. It was also noted that Uniply Decor Limited was also admitted in CIRP wide order dated March 22 in response to the IA, that is investigating authority query wide email dated 22nd of Feb 24. The Sundar replied that agreement between the CD and Uniply Decor was unilaterally terminated due to non-payment of the earlier dues. Now, something which is the crux of the case is this, which is 2.1.2. Mr. Sundar mentioned that Uniply Decor Limited has submitted its claim. So it is a CD which is in CIRP submitting claim. To the CD of this person is an RP. To the CD as financial creditor as well as an operational creditor. It was noted that the claim form submitted by Uniply Decor, who was using the trademark in the capacity of FC, was 119 crore, and capacity of OC was 35 odd amount, 35 crore, and both the claim were admitted in full by Mr. Sundar. It was observed that Sundar did not submit any claim before Uniply Decor Limited, accepted the claim, admitted the claim in full, but has not filed any claim before the IRP or RP of Uniply Decor. He submitted that the claim submitted by Uniply Decor in the capacity of OC was submitted after adjusting the debits and credit with CD. He is reaching to this conclusion. However, the IA did not observe any calculation sheet attached with the claim for evidencing the adjustment of the cross claim. Now, the question is whether cross claim is permissible in liquidation or yes, but whether the same is permissible in CIRP or not, that is also a subject matter of concern in this order. As IP or liquidator, it was the duty of him to collect and verify the claim submitted before him and file any claim on behalf of CD of which the person was or the Sundar was IRP or RP. The board was of the prima facie view that he contravened provision of 208A of the code, regulation 72H of IBBA insolvency professional regulation. Read with clause this of code of conduct of the first schedule. Now see his claim. Mr. Sundar submitted that Uniply Decor Limited has submitted a claim of the FC on March 22 and OCS April 22, totaling the claim amount to 119 crore and 35 crore 43 lakh 85,897. This claim amount were divided from outstanding dues from Uniply Industries Limited, as reflected in the audited financials of Uniply Decor Limited. This figure represented the net outstanding due after adjusting debit and credit of the same date. The reason to base the claim as on March 21 on net basis was reason of the RP of Uniply Decor Limited. As the claim was submitted on a net outstanding basis, the claim was also approved on a net outstanding basis. Having approved the claim on net outstanding basis, Sundar did not have any basis to submit any claim in CIRP of Uni. So he himself is not filing claim before the IRP or RP of the Uniply, as the amount payable to Uniply has already been adjusted and reduced in the claim submitted by Uniply Decor. Had the claim been submitted by Uniply Decor without setting off, Sundar would have filed a claim with Uniply. So this is the submission which is made by him. Will not go into much of his submission, but let's see the findings. The DC observed that the brand Uniply was owned by CD and the right to use the brand were licensed to Uniply Decor through trademark license agreement of 17. License was granted for 10 years with a total royalty consideration of 75 crore payable on quarterly basis. DC notes the submission of Sundar that no payment were made by Uniply Decor and Mr. Sundar terminated the agreement in 23. It is noted that Uniply Decor Limited also went into CIRP March 22. Now, this is something the DC observed that the CD was admitted in CIRP in October 21 and ordered for liquidation on May 23. Sundar has submitted that Uniply Decor Limited submitted a claim as a FC as a OC. DC notes that submission of Sundar that due to adjustment of the debit and credit in Uniply, he did not submit any claim in CIRP of Uniply Decor. Since the claim was submitted on net outstanding basis, it was also approved on net outstanding basis. And Sundar submitted that the claim already been adjusted and reduced in the claim submitted by Uniply Decor. He did not have any basis to submit any claim in CRP of Uniply Decor. And Sundar stated that he accepted the approach of RP of Uniply Decor, who submitted the claim based on the audited financials. There is a grave question of the valuation aspect as well. Pertinent to mention that unlike regulation 29 of the, this is very important, unlike regulation 29 of the liquidation regulation, which allow for mutual set off during liquidation, there is no corresponding provision for set off in CIRP in the manner of Bharti Airtel Limited and others and Vijay Kumar V. Iyer and other. Honorable Supreme Court observed that we should record that there is a difference between CIRP and liquidation process. CIRP focuses on and fosters rehabilitation, revival, and resolution, whereas liquidation process focus on the constellation of the assets of the company in liquidation and distribution and the payment to the creditor from the liquidation estate in terms of the order of preference set out in an estate. So basically, there was a question which emerged: mutual credit set off. The title of the liquidation regulation states that they shall apply to the process under Chapter 3, Part 2 of IBC. In other words, liquidation regulation are not applicable to Chapter 2, Part 2 of the IBC, which relates to CIRP. And that's why that mutual set of things should not be applicable if RP is placing its claim on the basis of that set off. DC find that since the set off of the claim during CIRP is not allowed, it was duty of the Sundar to file a claim of CD during CIRP, which he failed to file before the RP or the IRP of Uniply Decor. Thus, the submission of Sundar for accepting the approach of RP of Uniply Decor on set-off basis cannot be accepted. DC notes that Sundar has submitted that the claim of Uniply Decor Limited was based on the audited financials of that company. So set-off is yes. Resultantly, this set-off would not have taken into account the dues of accrued to the CD post the financial statement of Uniply Decor Limited. So that was not taken into consideration. The DC further notes that despite Sundar's lack of clarity on non-adjustment of royalty amount for year ended on March 31st, 21, and the fact of Uniply Decor Limited is a related party of the CD, and auditor's adverse opinion on its financial statement, he did not seek any clarification regarding the claim submitted by the RP of Decor. Now, the valuation aspect will be covered up very soon. DC observed that adjudicating authority had approved the resolution plan of Decor. The claim for use of, now this is very important, the claim for the use of Uniply brand by that company whose RP has submitted a claim on the basis of that financials after commencement of the CIRP on March 22 till termination of contract by Sundar would have been classified as a CIRP cost of Uniply Decor Limited, and I should be entitled to receive that amount. Such cost would have been prioritized for payment. However, this claim was neither submitted by Sundar nor was considered in the set-off. Similarly, during liquidation process, while set-off permitted, any claim arising after 31st March 24 usage of brand would have been remained outside the set-off. Hence, DC fined him that he failed to perform his duty by non-filing of the claim of CD in Uniply Decor Limited. This could cause a loss to the CD. DC hold him contravened the provision of this section and this regulation. Now, this is something which is related to the valuation aspect. It was observed that Sundar has submitted before IA that is during the course of investigation that the brand Uniply, it is submitted that the brand Uniply has been valued by the RV appointed during the process of CIRP as well as the liquidation, and no value for the said brand was determined. However, upon perusal of the valuation report for both CIRP as well as liquidation, it was observed that a valuer had not provided any valuation for the brand Uniply. So this is so important in terms of this intellectual property to be valued. And it's observed that he has made a misleading statement before the IA stating that the brand had already been considered for valuation by the valuer during valuation, wherein later on it will be found that the valuation was not sought even. It was noted that from the minutes of the SCC meeting that the discussion were carried out regarding monetization of the brand value. And SCC in its discussion with the Sundar had arbitrarily decided the value of the brand for initiating auction process. Accordingly, it was observed that he was negligent with regards to valuation of the asset of the CD. He submitted that replies received from the valuer were as under. Swaroop, so this is one of the liquidator. Uniply as a brand value cannot be determined and possible the value would be close to zero as the company is not into business from last many years, being in liquidation. Other valuer confirming that there is no value ascertained for the brand Uniply. This is his submission. This is his submission. Where analysis of the DC and the finding of the DC is the DC notes that Sundar has submitted to the IA that appointment of the RV both in liquidation and CIRP. Available information was submitted to the RV and valuation report were submitted to IP and liquidation as below. The DC notes that following the scope of work mentioned in the valuation report dated 12 September 22 submitted by one of the valuer during CIRP, wherein the scope of work as per my engagement data is this: to estimate the fair value and liquidation value of the following financial asset of the CD in accordance with this regulation. And so it has made it very clear that which assets are to be valued. With regards to the valuation, the valuer has stated that fair and liquidation value of the current and non-current asset as per the scope of valuation exercise, while the value of certain assets are not determinable, while certain assets are valued at zero, which stands the test of reasonability and defensibility as detailed in the valuation report. Upon reviewing the valuation report submitted by one of the valuer during CIRP, DC observed that no specific valuation of the brand has been provided. Valuer was appointed during CIRP has stated that the valuation of intangible, including brand iUniply, was not clear in the scope offered to him and accepted by him. Consequently, the valuation of the brand was not made by him as it was not in the scope of the valuation assignment. Further, for assigning nil value to a brand, another valuer has submitted that the trademark license agreement was cancelled. However, DC observed that such agreement was cancelled 23 after the closure of CIRP. Thus, justification cannot attributable for valuation during CIRP process. It was observed that the discussion have been carried out in SCC meetings regarding monetization of the value and arbitrarily amount has been arrived at during such discussion Based on the discussion and fixing of the reserve price, the auction process has been initiated by MIM. Thus, DC find that if the valuation report has explicitly included the brand valuation with due consideration, there would have been no need for arbitrarily monetization of the CD's brand value. DC views that during CIRP or liquidation, the valuation of the brand have been shown separately. Any agreement with third party for its usage could be considered in such valuation. Furthermore, during liquidation, once the agreement for brand usage has been cancelled, the valuer should assess its value irrespective of the agreement. Accordingly, it was the duty of the RP or liquidator to explicitly state to the valuer the assets to be valued, including intangible. Liquidator or the RP could not absorb his duty merely by sending the list of agreement to the valuer. Additionally, all valuer appointed for the financial asset of CD during CIRP would consult RP and liquidator and ensure that all asset, including intangible, are valued and shown in the valuation report appropriately. It is to be noted that the valuation plays a pivotal role in maximizing the value of the asset for creditor, ensuring a fair outcome of for all the stakeholder. Proper valuation of the company's asset is critical to ensure fair and transparent resolution or liquidation, and meaning thereby this is making, or this order is making it very clear that if the brand or the trademarks I've seen in the pharmaceutical companies, there are several products and the products are basic intangible asset for those entities which are doing the job work related things. They have their brand registered in its own name, and therefore while assigning a task of valuation, that brand or that trademark should not be under that valuation should be determined, and that should be encased. In view of the foregoing discussion, DC find him negligent with regards to valuation of the asset. DC hold that he contravened the section 208, and see the order. When these orders are being passed, see the manner in which the orders are being passed. The order shall come into force after expiry of 30 days. That is what we have studied. The copy of this order shall be forwarded to IPA, wherein he is the member. The copy of the order shall be sent to the stakeholder consultation committee of the Uniply Industries as well. Copy of this order shall be sent to the COC stakeholder consultation committee of all the CD, wherein he is providing his services, and COC and SCC may decide whether to continue his services or not. In case if the COC and SCC decide to discontinue service, they may file an appropriate application before the adjudicating authority. Copy of the order will also be sent to the registrar of principal bench of the NCLT for information, and accordingly show cause notice is disposed of. Meaning thereby you will find this fact that this is what the action has been taken, that suspension the registration of for a period of 2 years. So this is how, and the most important heart of this order is this only, wherein some indication or the learning which states that if I have been appointed or any person is appointed as an IRP or RP or the liquidator, while making the statement of seeking valuation, or whether the purpose of seeking valuation, if say there is no property involved, but if there are some intangible, that should be identified. And because the same thing when will be placed for the auction, you cannot bluntly give any reserve price for that unless that asset gets valued, whether it is a tangible or the intangible. This is one of the order which I found that is having so learning out of it in terms of the valuation aspect. There is one more,
किसी का
please sir.
अरे तो वही तो नया ही है बिल्कुल
I think this is not related to our session. We should move on with the other one.
नहीं है गैस भरेगी तो क्या होगा तुम तो ऐसे ऐसे कह रहे हो 6400 रुपये कोई चीज ही नहीं होती ऐसे ही तो
Sir, may you please mute? This is the another order of the disciplinary committee, and this is again a very recent order in terms of its date 6th March 2025. And let's identify.
इतने कैसे चलते हैं मतलब
Okay, sir. I request you to please mute so that
अभी क्या हो गया?
Gupta ji, it's humble request if you can please mute. So as far as
नहीं, वो तो कोयल में क्या हो गया ऐसा?
Anjali ma'am, please if you can mute the participants.
Sure, sir.
हाँ,
Thank you, ma'am. If there is any question, we can certainly address upon, and you can unmute and we can.
नहीं तो फिर एक बार उससे कंसल्ट करते हैं ना क्या कहता है.
Ma'am,
ठीक है,
please
तो
do
बाकी
the
टीम की
needful.
तो कर दो. हाँ.
Sir, now you can continue.
Please, ma'am. Thank you. Now, this is a concern wherein you will straight away we can reach out to the aspects and will reach out to the analysis and finding. So when you see the contravention, and I was indicating this order time and again, delay in filing of dissolution application. This is one of the contravention, and that is contravention number one. You also will find the contravention number two. And as far as this contravention is concerned, there is a case of non-cooperation as well, but that was not reported to the adjudicating authority on time. Now, when you see this particular finding or this concern, the balance sheet of the CD for the year March 18, the CD had investment amounting to 5 crore, as shown in two companies. These shares were sold by the directors of the CD prior to commencement of CIRP, for which avoidance application was filed by the erstwhile RP on August 29. It was submitted that there was no realizable asset and filed the dissolution application before the adjudicating authority. This is case against the liquidator. The Sonu Jain mentioned in a reply that during the investigation that the directors were not cooperating with her for asset realization and ascertainment of the statutory details. No application was filed by her against such non-cooperation before the adjudicating authority. From the above, it was observed that she prolonged the filing of dissolution application, failed to complete the liquidation process within the period of 1 year despite there being no realizable asset. Further, dissolution application filed by her was incomplete, and this is very small task, which or this was just because of the non-submission of the final progress report in Form H. This action was initiated. Incomplete in absence of the final report in Form H. She also failed to approach adjudicating authority for non-cooperation of the director of the suspended board during liquidation process. We can straight away jump to the findings rather than going into the merit of the case and submission of the concerned IRP, RP or the liquidator. The DC notes that the liquidation of CD commenced via the adjudicating authority's order dated November 19. DC notes submission of Ms. Sonu Jain that she communicated with the directors of the suspended board through several emails and letters seeking information about CD. The DC also notes that the liquidator pursued the application filed before the adjudicating authority by erstwhile RP in the present matter, wherein the direction was sought for return the non-current investment amounting to 5 crore, along with the direction to hand over the assets of the CD. Said IA was dismissed as infructuous by the adjudicating authority in March 22. Disciplinary committee notes that the said application filed by erstwhile RP was under section 43, 45, 49, 66, 68, 69 and other applicable provision. DC further notes that the adjudicating authority wide order dated July 19 disposed of that application filed under 19 of the code for a direction upon the promoter to cooperate. Hence, no application was pending for non-cooperation. DC notes that along with the efforts of sending mail, application under regulation 9 of the liquidation regulation was required to be filed by the liquidator for seeking direction against the board of directors to extend their cooperation. Thus, the liquidator made incorrect submission regarding pendency of the application for non-cooperation against the director for the suspended board of directors. Liquidator has filed dissolution application in April 22, which was rejected by the adjudicating authority due to absence of Form H. DC notes that the submission of liquidator that said dissolution application has been prepared by some advocate and Form H was inadvertently missed by a junior of the advocate. However, it is the responsibility of the liquidator to ensure the filing of the dissolution application correctly with all required enclosure. Form H is important document mandated by Regulation 45(3) to be annexed with the dissolution application. Therefore, putting the blame on somebody's junior for missing Form H with dissolution application is not tenable, as prime responsibility of all action in action continue to rest with liquidator. DC also notes that the liquidator has stated that CD had no realizable asset. When CD has no realizable asset, there was no point in prolonging the liquidation. Liquidator filed the final report before the adjudicating authority on 31 March 21, almost 1.5 years after the liquidation commencement date, and resolution application was filed 1 year thereafter in 22, thus necessarily delayed the conclusion of the liquidation process. This is one of the order which clearly indicates two aspects, that at relevant point in time, section 19 application is required to be preferred, because tomorrow this cannot be a basis or this cannot be a ground of uh, substantiating the delay that there was a case of a non-cooperation, and the counter would be then why the necessary application was not made. And second one is when the liquidation was required to be completed within a definite time frame, why that was extended, or even if that was extended, why dissolution application was belatedly filed. That is going to be the third aspect. I'm referring to one more.
Sir, excuse me. Sir,
Please.
in regarding to PUF transaction, no, we are filing a IA during a CRP and on various grounds for various, reason. It is keep on prolonging during liquidation also. Even after disposable of assets also, it is continuing. How to put a full stop for that, sir? We cannot extend liquidation, no, for this continuing this PUF transaction IAs.
This is a subject matter of concern before all the liquidators and RP, because when the assets have been disposed of, this
Mm,
forfeit transaction application lose its you can say significance,
mm.
and because of this delay in disposal of this application, the dissolution orders are not being passed. Understand?
Uh,
No,
uh, During this time, who will incur the cost, sir? Cost
absolutely.
of
So,
litigation as well as the time is also going on, and we need to keep on file the progress report, final report. Every many things are there, no?
and every
Uh,
such compliances are having its cost associated with the same. I understood this. But
yeah.
again, now as far as 43 or 66 is concerned, I've not seen much orders wherein the things have been reversed and something has been achieved by the conclusion of that application. But again, when we see the provision of the court, there is no clarity in that aspect. I would like to refer to one more case wherein the the corporate debtor was ordered for liquidation and thereafter it was sold as a going concern. So when it was sold as a going concern, I being a successful auction purchaser, in any case, I'm not going to be benefited by those outcomes of those 4366 application. I'm not going to be benefited in any manner. And hence, I have decided not to pursue that application, because when the company has been purchased by me, then the cost title will be changed, because now the applicant will no longer be the liquidator. It is the successful auction purchaser who is going to be the person who is going to pursue that application. Now that happens because if I'm not going to be benefited by the outcome of that application, why should I pursue that application? That is question one. But now the question two to this fact, this a substantial amount of time and substantial amount of cost has already been incurred for that application. I must have paid to the forensic auditor. I must have paid to the transactional auditor. I must have paid to the lawyers, the counsel as well. Regarding my point, ma'am, And all those
Yes, sir.
forms were
Yes.
part of my CIRP cost. Subsequently, that has been incurred by me as a successful auction purchase. And now, what is the fate of this application is always a subject matter of concern. I understood your point wherein your company was liquidated. Here, my point of concern is I've purchased that company during the process of auction for selling of the corporate debtor as a going concern. Now, suppose if I pursue, it is going to be a cost on me and I can incur that cost. But in consideration of what if I'm not going to get anything? And second question to this fact, if you being a liquidator has liquidated the asset of the company and already discharge your duties as a liquidator by making distribution as per 53, from where you are going to get the necessary costing, who will bear, whether the financial creditors are going to bear it or not, and at what cost, because till it get prolonged you will not get a dissolution order. So I understand that there is a substantive clarity is required in such cases. I understand your concern to that, especially if you are the victim of this process. I was
So there is one provision in this liquidation process regulations,
Hmm.
regulation 44A,
Regulation 44A.
which
Yes,
deals
what
with
is that,
this
sir?
situation. The liquidation regulations.
Please, sir. If you may share, sir. Yes, sir. If you may please zoom a bit.
Yeah, treatment of avoidance transactions.
Sir, if you can please zoom.
Yeah.
Yes, sir.
May I
It's
read
it's
it?
it's visible now.
Yeah. So this answers to some extent.
Yes, sir. It's a liquidator shall, on the advice of the consultation committee provided in the application along with the final report, file under Regulation 45, for the manner in which the proceedings in respect of avoidance transaction, if any, under Chapter 3 or the fraudulent or wrongful trading under Chapter 4 of Part 2 of the Code will be pursued after the dissolution or the closure of the liquidation process, and the manner in which the proceeds, if any, from shall proceed. So I agree to this point, that is Regulation 44A. But now the point is, who will be ultimately benefited? Who will be ultimately benefited? And answer to this is the creditors.
Right.
But ultimately, on whose cost this is going to be continued?
The
And
creditor will have to incur the cost because they are going to benefit out of it if at all.
will they is another question, because again there is an anticipation, or there is always a two-way anticipation, or there is always a contingency associated with the same. And now the question is, can dissolution order be delayed for this sake? This is was the concern of the another participant, because till it get continued there is a cost associated, and the dissolution order will be prolonged till this application will be decided. And there is a timeline which is framed for closure, or for with the adjudicating authority as well, that within this time frame they have to conclude or they have to hear it out. So I agree to this point, that this is an answer to to a concern up to certain extent. But now, practically, how this is going to be benefited the stakeholder, and at whose cost, and whether that cost is going to be complied or going to be discharged by the creditor is a question.
That is the liquidator and the that SCC, they have to sit together and take a call on this. That is what this regulation says.
Right. What your views on it, sir?
I have not yet come, I have put it before the SCC, but they
Hmm.
have not yet decided on that.
Because this is one of the major concern that after getting the necessary distribution post disposal of the asset as per 53, are they going to incur any additional cost? That is point one, because that cost will inclusive of the cost payable to or the amount payable to liquidator on per month basis. Now they will be having their counter argument that what the liquidator has to perform now when the distribution has already been concluded. Why this cost? Liquidator has his own concern that because he is the representative or he is representing before the adjudicating authority and incurring some additional legal cost of his advocate. So this is always a subject matter of debate because there is no timeline which is akin with regards to disposal of such application.
One suggestion came from SCC was to sell this rights for whatever outcome will be out of these applications as NRRA and then dispose it off.
Correct.
I tried that, but that did not come through. Nobody responded.
Right, and that's why this is what we have seen. Multiple practical difficulties are still associated with the process. And suppose if we take any such kind of decision, there is always a counter on the part of the COC member, and they have always their records available. They approach DC, and we face such kind of proceedings. It happens, and that's why we generally don't think beyond that box, and we stay within what has been decided by the COC. But I feel that at this moment, even the this consultation committee, even the creditors are not so much confident enough to gain out of it. And
because they also know it's very difficult to recover anything out of these applications.
absolutely, and there's no so when you see the precedent in this connection, you will not find many. And that is again subject to further challenge before the next forum.
It is made to execute that and make the actual recovery. That is another time prolonged process. Yeah.
Right, sir.
Sir, now they brought the provision of NRRA. Under that, we can shift this, transactions. Only if it is possibility is there for recovery. To some extent,
Absolutely.
they can do, and with the monetary committee.
Absolutely.
Otherwise, it is not possible. In that situation, how to put a full stop to that is my question. Whether to leave it as it is and close. If it is going on concern, we can transfer the suit to the buyer, and
To
it
the
is for
buyer.
the
But
buyer.
again, the question is why a buyer would be willing to pursue when he is not going to be ultimate beneficiary.
Yeah, it is left to him. It is left to him. If
Correct.
it is not taking, then again that portion will be there in the balance sheet.
Absolutely.
So how to solve the issue is the big question.
There's a big question.
Yeah. And
Right.
another one issue, sir, sorry. Earlier, you were discussing about that SURFACE and Section 14 moratorium, and
Right.
IP has not taken the position like that. One ma'am was discussing in Santan Lakshmi.
Correct.
In that case, no, like that, a similar case, there was a property of 20 acres. In between the 20 acres, 5 acre is under the control of the insolvency professional. I mean
Hmm.
RP. Already, when the RP has taken the control, the property was under the control of the financial creditor. They have appointed the security. That 5 acre is the vacant land, and only one small building was there. In that situation, the RP is not able to appoint a security only for that 5 acre. That too also
Correct.
the cost is waste. I mean, banker is giving already for entire 20 acre. Then specifically for that in between middle property,
Hmm.
where waste for the RP to take control and appoint separate security for that. So in
Correct.
how to handle that situation is very complicated to decide. So
Absolutely.
in such a situation, how to approach and where to go for a consultancy,
See,
that are all
ultimately,
lacking.
when you see the rationale of this code qua
Mm,
taking possession of the assets, the
mm,
rationale is very much confined that to oversee that that asset should not be misutilized.
Yes.
The purpose or the rationale behind this provision of the code is taking physical custody or taking the custody of all the assets of the corporate debtor which are there in the balance sheet of the company, and otherwise also to see what are the assets available in the name of company, to take the custody just in order to avoid its misutilization by the suspended board of directors. Now, whether to incur cost pertaining to engaging a security guard, valuation is unavoidable aspect which you are supposed to do, but engaging somebody to take the custody when there is a need, it's always a call which ultimately going to be decided by the COC in pertaining to the engagement of any security personnel. Otherwise, what you need to take care of is that asset should not be in any manner is under the control of the suspended board of directors. So until you have the custody in terms of the entire control over that premises, act or the court does not mandates you to mandatorily have a security personnel to take care of that premises.
Thank you, sir.
Yes, ma'am. Now, considering the time frame, I would like to invite the concerns, if any, from the participants pertaining to the discussion which is ongoing and pertaining to a relatable. Yes. Any of the concern or any of the question pertaining to what we have. Yes, sir. So to conclude, I would like to say that apart from what we have in that code print of this IBBI IP regulations 2016, there is a manner or there's a code of conduct which is prescribed, but there are several aspects or there are so many practical difficulty which we generally face when we are the one who is handling the process. And that practical difficulty, we don't have any solution to that effect. And I believe that in this process, in such circumstances, like we have one of the participant where there was a concern pertaining to some threat email coming from the suspended board of director or the promoter of the corporate debtor. And I believe that it is not only for the complainant who will approach the IBBI, and it's the IBBI who shall initiate an action of the inspection or the investigation and shall issue a show cause notice. It's also you being one of the primary stakeholder or you being one of the officer appointed by the tribunal, facilitated through the decision of various decision of the committee of creditors in several situation or on those condition wherein you are not getting a direct response to that situation, you can, it's always advisable to take the adjudicating authority into confidence before you take any such decision, because if you are taking any such action without seeking the consent or without taking that particular authority into consideration, the disciplinary committee may take its own stand during that case, that why the necessary application was not made, or why the COC was not been approached, or why the consultation of the COC together with the approval or the directions of the tribunal, the adjudicating authority was taken prior to acting upon this action. So I believe that as far as the things which are directly attributable to the situation wherein you have got a clear answer to your query or clear answer to your circumstances which you are facing, and if you have the clear answer to that, or if you have a clear stand or clear procedure which is prescribed in the code, then there is this not a subject matter of concern. But otherwise, the rationale of code to be understood, the intent of the code to be understood, you need to take care of whether the interest of the stakeholder, not only the COC, but other stakeholders are being preserved or protected or not. And who will be the ultimate beneficiary of your act, or who will be the ultimate, or which stakeholder is going to be impacted if this step is not going to be taken care of. These are the aspect you should consider, that who is going to be the person aggrieved of your act or of your inaction. I believe the person aggrieved of your action or inaction is something on the basis of which you can decide whether to approach COC, to do or for not to doing such act, to approach the adjudicating authority for doing or for not to doing such not to do such act, and finally it is the adjudicating authority, even though if it is not been a subject matter of their power, but it is always that you should move an appropriate application, seek the necessary prayers. If it is permissible, that is going to be granted. If not also, then you will get necessary clue that how to react and how to opt in a specific subject matter or in a specific circumstances. That is what I believe. Otherwise, this disciplinary this committee's orders which are being day in day out being uploaded on the IBVI web portal are going to be the ultimate guide to understand what is going to be the modus, what is going to be their viewpoint, what stand they have taken in a similar placed situation in which the order has already been passed, and what stand they have taken in similarly placed a situation that is going to take or that is going to help you out to identify whether to opt, what to opt for, when to opt for, when not to opt for. And I believe that all this being taken care of considering the overall rational or overall objective of the court. That's it for me to discuss or to deliberate upon. Still, if you have anything to discuss, I would be happy to address. I'll be happy to deliberate. I'll be happy to answer. Otherwise, I would like to conclude the session with thank you for the patience listening for entire 3 years. Thank you very much.
Sir, I have a query.
Please, sir.
Actually, this is a matter which I'm handling is a liquidation matter.
Okay, sir.
And there is a very large PSU for which the corporate debtor has done some work.
Okay.
And the site is at a very remote location. I am based in the east and the site is in the north of India.
Correct.
Okay. So what happened from the books of accounts and after having discussion with the auditors and after going through the whatever records which was available with me, I got to know that there is a X amount which is receivable from that party, from
Okay.
that PSU.
Okay.
Very large PSU. So what happened that we have visited that site from the erstwhile RP. When I took this assignment as a liquidator, so I discussed with him also. He said ki yes, the amount is receivable and we have also approached them several times, but they are not cooperating.
Correct.
When I also went to the site, I realized that there are 2-3 persons from the finance department, one from operation department. Actually, they are playing foul. They are not even giving me any information about the amount receivable from them.
The work been undertaken and the amount receivable.
Yes, the amount receivable. They are not giving entire picture to me. And instead, they are telling me that, see, there are some labor payment pending, so I can pay on your behalf. You give me the clearance, we will pay your labor. So I said, this is a preferential transaction, you cannot pay like this. If anything need to be paid, then they have to file a claim and we will pay.
Correct.
You pay us the amount which is receivable from you.
Correct.
So I then after the discussion and everything happened, then they said we have a head office at Kolkata, so you can go and have a discussion there. My office is also in Kolkata. I'm based in Kolkata. Then he just said you can have a meeting there. So we came back to Kolkata after that visit. Then we tried several times over email to have a meeting with them, but they are not giving any time to us. And they're not giving any response also. Instead now, verbally, they started saying that we also have a counterclaim. Since you have not completed the entire task, there are some work pending. So since you have not completed, we also have a counterclaim. But they are not filing any claim as such. So
Correct.
time for filing claim is also gone.
Correct.
So whether I can take any action against them for their non-cooperation, or I can write to their board of directors that kindly look into this. These few people at this site are actually playing foul, and there are laborers whose amount is due, and thus they are asking me to that they were ready to pay directly to the labor, but they are not giving me that amount.
Correct. So basically, there are 3 concerns. Concern number 1 is there is an amount which is recoverable from the from the debtor of the corporate
operational
debtor.
Yes.
The debtor of the corporate debtor.
Yes.
Point number 2 is there is a concern with regards to claim of their laborers.
Labor are the labor of the corporate debtor.
Okay, which they have not filed their claim.
The laborers have filed their claim.
Okay.
But this since they are the principal employer, so they are
Hmm.
saying we will pay it directly instead of paying the corporate debtor. We will pay to the labor of the corporate debtor.
Okay. And third concern which is being raised by you is to initiate an action against them for non-cooperation. I must say there is no provision with regards to going against any stakeholder of the CD for
Right.
non-cooperation before the adjudicating authority. The
Yes.
only recourse available is to initiate necessary legal action for the recovery before the appropriate forum or before the appropriate court of law.
Right.
Now, this is not a stage wherein if that stage is closed during CIRP, if there was any counterclaim from their side, you have not received any claim. At
No.
this stage of liquidation, there is always a definite timeline within which, if there was any counterclaim, they should have placed. Now, this is claim subsequent to your approach to that party, approach to your debtor, and from there you came to know that they have some counterclaim, whether a legitimate or the otherwise. For that, right now, the only action which you can opt for, if there is a possibility, because if there is a possibility of getting some recovery out of that, taking that consultation committee into consideration, you can very well initiate an action against that party on behalf of the CD which is into liquidation before appropriate forum or the court of law. You can very well approach, but adjudicating authority is not going to be the authority where you can approach for non-cooperation, because this is not a case of non-cooperation from your management. This is the non-cooperation from a third party from which you are supposed to recover, but no recovery is made due to their inaction.
Right.
You can
Actually,
very
I
well.
also like to bring this things before the board of director of that company also, that there are few
Correct.
people that I'm allowed to do now.
Which your RP has also undertaken, as you have mentioned, that even he wrote to those the email or the correspondence with your with the CD's debtor, but you
Yes.
have not received any response or you have not recovered anything out of that effort.
Right. Right. So whether I can bring it to the knowledge of the board of director or the ultimate management, because
Absolutely. And they should be the first person to approach, or they should be the first authority to approach, rather than approaching their subordinate or their the hierarchy below the board level. It is always advisable to first write to your debtors management that this is the amount which is recoverable and the company is in liquidation, and this being a part of the liquidation asset.
and even these people are not acting in the interest of the debtor of the corporate debtor as well, since they are not filing any claim.
Absolutely, that is an aspect you should not generate or you should not comment upon. It is they or it is their prerogative to submit claim. Not to submit claim is absolutely not a subject matter of dispute, and you will not get benefited out of it. The only matter you should stick with is the receivable or the amount which is recoverable but not received.
Okay. Thank you, sir.
Anything else?
Sir, I have one small question, sir.
Please, ma'am.
Sir, now recently in the matter, it was decided that resolution professional has no authority, no power to initiate CARP against the debtor of the corporate debtor. Debtors of the corporate debtor, even though they have to pay, RP has no authority to initiate CARP against that company who is a debtor for corporate debtor. Now, in our matter, actually the corporate debtors promoter has initiated individual insolvency prior to CARP commencement. So, being an RP, I want to transfer that matter to NCLT because it was initiated before civil court under the repealed act actually. So now it has to be transferred to the same adjudicating authority who is handling the CARP.
CIRP of the corporate debtor.
Yes, yes. So do I have that power? Should I initiate, or if somebody else can transfer it?
The question is, who moved that application? Was it a voluntary application by the promoter?
No, it is actually Section 9 application, wherein I was appointed as IRP and subsequently confirmed as RP.
Correct. But with regards to the insolvency application of the promoter,
That is initiated by himself.
he
That are
himself
by
initiated that application.
yes.
You can very well seek the direction of the tribunal, but when it was a voluntary application, you can bring an attention to the adjudicating authority that why this application necessarily required the adjudication by this honorable tribunal, considering the fact that this is a matter of the personal guarantee and the CD is before this honorable tribunal. So I believe that you should bring an attention of this tribunal that why the case required to be transferred.
Okay. So, shall I file an application to reject the plaint before the lower court where the case is pending? We have to file a reply in it. Being an RP, instead of filing a reply, I am planning to move an application to reject the plaint because there is no jurisdiction.
So
In
you
view
should
of
approach that jurisdiction, the court or the forum which is right now entertaining that personal insolvency matter. Should approach that.
yes, before
Yes,
the lower court.
correct.
Okay. Yeah. Thank you, sir.
If any concerns are there, we can
Sir,
certainly.
actually, I have one question regarding the actually what happened that in liquidation there are only operational creditors, and
Okay,
during the CRP, the liquidator there is no asset to recover, and the COC is not SEC is not approving any fee payable to the liquidator also, and
correct.
so how to go ahead with this situation?
A very difficult situation wherein your entire member of the committee is going to be a contributory only and they are not going to gain anything out of it.
Yeah, and the operational creditors, can we insist on operational creditor because there is no financial creditors, and whether we can say that operational creditors should contribute or something like that?
They are bound to contribute. The reason behind,
Hmm?
if they don't contribute in such circumstances,
Hmm.
there is no procedure, there is no way out. You are going to continue that liquidation process.
Yeah, yeah. So but only the PUFE transactions are there during the CRP and they are continuing. So I cannot go for dissolution also directly.
Absolutely, sir, and that is
So
what we were discussing as well.
okay. So what to do in that case? We have to expend from our own pocket
So it
and.
was a PUFE transaction initiated by you with the committee's consent. You can withdraw that, I believe, and I
Uh-huh.
believe that go for early dissolution.
Okay. And if committee is not giving consent, that is why they are not voting for anything. They are not voting
See,
anything.
this is something they cannot take this contrary call. One time they want this PUFE transaction to be continued.
Uh-huh.
Contrary, they don't want to contribute towards the cost which is being incurred by you.
Huh.
Both things cannot run parallelly.
Okay, okay. So we can convince them that either you go for withdrawal of.
Early dissolution is the only option they should opt for. It
Uh-huh.
is them to decide whether they want or not, because dissolution can only be opted for once that PUFE transaction application get withdrawn.
We cannot go now without means we
You
cannot go
cannot.
to the.
You cannot.
And I just want to know the how this assignment of PUFE transaction happens. Actually, I don't have any much idea about that.
Come
Assignment of
again.
assignment of PUFE transaction. I have heard that sometimes the assignment can be done for PUFE transactions.
Assignment. I'm not exactly getting your query.
Actually, how the PUFE transaction are assigned to somebody else who can take this because I have seen in some e-auction the receivables from the because I didn't have much idea, but the only the advocate have convinced to the court that they want to looking for the assignment of PUFE transaction.
Got your point. So basically, whatever may be the PUFE transactions outcome, or
Hmm.
whatever may be your claim or prayer in the PUFE transaction, the ultimately those asset of the corporate debtor, which is again a contingent that will be assigned. There's
Yeah.
a separate procedure which is prescribed. I'll share certainly
Hmm.
the procedure or the modus which is prescribed for that to the ICSI IIP so that it can reach out to you.
Okay, so I just if not reach, can I call you?
We'll
Have your help?
certainly we'll do that.
So, can you have no number or mail ID something like that?
Can get it from institute, sir.
Okay,
Thank
thank
you.
you, sir. Thank you very much.
Thank you, Institute, for giving this opportunity to have a deliberate on a very serious aspect, considering the numerous litigation which is being referred by the either the member of the COC or the suspended management of the corporate debtor or any aggrieved who has not been classified as a successful resolution applicant. To counter those issues, to address upon those issues and to take a very regular watch on the conduct of the professional, the fellow professional, and the stand which is being taken by the disciplinary committee and before that by the IBBI. It is important that that is going to be the ultimate manual for us to guide how to work, what not to work during a specific circumstances. Thank you very much. And it's always a pleasure to be a part of such a discussion. I once again give my or extend my thanks to the institute and to all the participants for having their inputs on the subject and for giving me an opportunity to address my point in detail. Thank you.
Thank you, sir. Thank you.
Thank you so much, sir,
Thank
for
you, sir.
clarifying
Yes,
all
sir.
our doubts.
Thank you, sir. Thank you for good communication. Good.
Thank
We
you
are
very much.
clear. Thanks very well.
Thanks a lot, Joshi sir. Thank you.
Thank you very
Thank
much.
you very much, sir, for giving your time and sharing your experience in the field.
I'm
Thank you very
extremely
much,
sorry
sir.
for rescheduling of this session, but it was due to some unavoidable circumstances. It was required. Thanks a lot to all the participants. Thank you.
Thank you very much, sir.
See you again.